Well, good morning, ladies and gentlemen. A very warm welcome to the HCCH Asia Pacific Week 2023, and a very good morning to you all. Thank you so much for joining us for the last day. I know it's really hard to believe that we've reached the final day of this 4-day conference, right? Time truly flies. And as a host, my name is Emilia Sun, in case you forgot, right? It's really been an absolute pleasure to accompany you throughout this significant 4-day conference. And we value your presence and contributions very much on these critical topics and issues that we've explored during this event. And once again, thanks for the generous support for the Department of Justice of the Hong Kong SAR and the Faculty of Law at the University of Hong Kong. Continuing our conference theme of access to justice and sustainable development, the impact of the HCCH in an interconnected world, today's focus is on international family and child protection law, encompassing 3 enlightening sessions. Now we will commence with the first session, delving into the 1993 Adoption Convention. And I'm very delighted to invite 3 speakers to join us on stage. Let's welcome the Honorable Justice B.B. Chu, Judge from the Court of First Instance, High Court of Hong Kong SAR, People's Republic of China. Welcome to join us on stage. Please have a seat. And let's welcome Professor Elizabeth H. Agaling Panalonga, Director of the College of Law and the Institute of Human Rights at the University of the Philippines. Welcome, join the panel. And Ms. Iris Liu, Director of the Adoption Program at the Cross-Boundary and Intercountry Social Service in the International Social Service Hong Kong branch. Welcome to join us on stage. Please have a seat. So, podium.
Good morning, everyone. Thank you, HCCH and all the organizers, for inviting me to give this introductory presentation on the 1993 Convention on Protection of Children and Cooperation in Respect of Intercountry Adoption. Today is the last day of this year's HCCH Asia Week. Last, but not the least, we have come to what, in my view, is a very important part of the work of HCCH, which is in relation to international family and child protection. The 1993 Adoption Convention is one of the core conventions. The core conventions are prioritized based on their recent adoption, popularity, or practical relevance. In fact, this year, we celebrate the 30th anniversary of this very important convention, which has remained of practical relevance throughout all these years. And now, to give a brief background of this convention was concluded on 29th of May, 1993. It has been explained by Professor Para Aranguren in paragraph 6 of his explanatory report that the reasons for the need of a new convention at that time included a dramatic increase in international adoptions, serious and complex human problems and complex legal aspects, and insufficient existing domestic and international legal instruments and need for a multilateral approach. The principal features of this convention were explained by the former Secretary General of The Hague, Hans van Loon, in his 1990 report on intercountry adoption. The convention was developed to give effect to Article 21 of the UNCRC, which, as you all know, is the United Nations Convention on the Rights of the Child, to ensure that intercountry adoptions take place in the best interest of the child and with respect for the child's fundamental rights. It was to also give recognition to the principle of subsidiarity. Subsidiarity means that growing up in a family is of primary importance and is essential for the happiness and healthy development of a child, and that inter-country adoption may offer the advantage of a permanent family to a child for whom a suitable family cannot be found in the child's country of origin. The convention is to set out clear procedures and also for adoption and prohibiting improper financial or other gains. Is to establish a system of cooperation between authorities in the states of origin and receiving states, to guarantee the automatic recognition of adoptions made in all contracting states, and also to provide for a system of central authorities in all contracting parties and to impose general obligations on them. The People's Republic of China signed as a contracting party to this convention at the end of November 2000, and it was ratified on the 16th of September 2005. The convention came into effect in mainland China on the 1st of January 2006. In accordance with the Basic Law of Hong Kong, the Central People's Government decides that the convention applies to Hong Kong. As a result, our adoption ordinance underwent major amendments in 2004, and in particular, a new Part 5 was added to provide for convention adoptions. And the new provisions, pressed too quickly, came into effect on the 25th of January 2006. So by next January, the convention will have had the effect in Hong Kong for some 18 years. In total, there are 48 articles in this convention. 27 articles apply to Hong Kong. It's being set out, they're being set out in the Schedule 3 of our ordinance. As to the remaining 21 articles, 5 articles actually have been included into the main body of our ordinance. And 16 articles have been excluded for reasons mainly because they confinements or they operate on an international plane, or they can be implemented administratively, or they are simply not applicable to the circumstances of Hong Kong. There are 7 chapters in this convention, which are set out there. But due to time constraints, I can only highlight a few articles. The first one is Article 2. Article 2 states that the convention applies where a child habitually resident in one contracting state, that is the state of origin, has been, is being, or is to be moved to another contracting state, that is the receiving state, either after his or her adoption in the state of origin by spouses or a person habitually resident in the receiving state. That's the main gist of Article 2. And you can see from that provision that the prospective adoptive parents, they are to be spouses, they can be spouses or a single person. The expression spouses was subject to some discussion at the time when the convention was brought in. There were discussions whether the convention should actually cover adoptions applied for by non-married persons of different sex cohabiting together or in a stable manner, or by persons of same sex living as a couple individually. It was then decided that the problem should be left to be solved according to the internal law of each contracting state. Of course, they may, according to their own laws, they may refuse the agreement for adoption, or they may be entitled to refuse its recognition on public policy grounds, which is permitted under Article 24. Today, Issue of another kind may arise because persons of same sex may lawfully marry in a contracting state and may fall within the definition of spouses. So it will be interesting to see how many states of origin will be prepared to accept their applications. Another article which I would like to highlight and which I think is an important article is Article 4. Article 4 stipulates the responsibilities on the state of origin. It provides that an adoption shall only take place if the competent authorities of the state of origin have established that the child is adoptable and that an inter-country adoption is in the child's best interests, and have ensured that the persons, institutions, and authorities whose consent is necessary for adoption have been counseled and duly informed of the effects of their consent, and that they have given their consent freely and not induced by any payment or compensation, and that the consent of a mother has been given only after the birth of the child. Then the next Article D, also part of Article 4, Article 4D, or 41D, I think, is the central authority of the state of origin must also have ensured that, having regard to the age and degree of maturity of the child, that the child has been counseled and duly informed of the effects of the adoption and of his consent where such consent is required. If consent is not required under the law, then consideration still has to be given to the child's wishes and opinions. And then the child's consent must be given freely and has not been induced by any payment or compensation of any kind. Thus, to summarize, Article 4 basically provides that no conventional adoption shall be granted unless the competent authorities of the state of origin have verified compliance with those specific conditions, which is the adoptability of the child, the subsidiarity principle, the necessary consent of all the persons, and if required, the necessary consent of the child and the child's wishes or opinions. As highlighted just now, insofar as Article 4C1 is concerned, the persons whose consent are necessary, that such consent shall only be given after appropriate counseling. Of course, in the cases where the consent of institutions, authorities is concerned, then there doesn't really need to be any counseling. But if you're talking about parents or family members, then their consents will have to be given after appropriate counseling being given to them. And also, Article 9C has prescribed that the central authorities are to take all appropriate measures to promote the development of adoption counseling and post-adoption services in their states. Article 4D, as we have seen, concerns the consents, wishes, and opinions of the child. Of course, we have to have regard to the child's age and degree of maturity. Article 4D1 only imposes the obtaining of the consent where required. So whether this is required or not will depend on the applicable law in the state of origin. But again, the consent must be informed consent. And again, it requires due counseling and information of the effects of the adoption. The effect of the adoption means it's also been provided by Article 26(1)(a) and B. It's whether the adoption is the effect of the adoption terminating the pre-existing legal relationship between the child and his parents, or as the case would be with his other family members. It has also been remarked in the explanatory report that the consent of the child is to be given not just to the adoption in general, but for the specific adoption in a particular case, since it would be against his or her fundamental rights to have the child adopted without even knowing who the adoptive parents are going to be. As I understand, in a recent case in Hong Kong during the COVID, of course, it's not that easy for the adoptive parents who were in America to fly in out of Hong Kong to come and see the child. So one way to enable the adoptive parents to meet the child to be adopted was through video conferencing. So there was video contact. And to ensure that the child, his views were to be taken as to in respect of that specific adoption by those specific adoptive parents. So even if the child's consent is not required, then Article 42 still ensures that having regard to the age and degree of maturity of the child, his or her wishes and opinions have to be taken into consideration. However, it's not quite clear whether there needs to be also prior counseling and information given to the child before his or her wishes or opinions are being sought. In my view, they should be. In Hong Kong, there's no statutory requirement for the consent of the child to his or adoption. But under our Guardianship of Minors Ordinance, in relation to custody and upbringing of the child, the court shall have to, it's a mandatory to regard his best interests and as paramount consideration. And doing so, we must give consideration to the views of the child, if having regard to his age and understanding and the circumstances of the case, it is practicable to do so. Article 9 and Article 32 concern the financial aspects of inter-country adoption. Article 9 imposes responsibilities on the central authorities of contracting states. They are to collect and exchange information about the situation of the child. They are to facilitate, follow, and expedite proceedings. They are to promote the development of adoption counseling and post-adoption services, as I've mentioned earlier. And they have to provide each other with general evaluation reports about the experience with inter-country adoption. This is after the adoption. And also reply to justified requests from other central authorities for information concerning a particular adoption situation. Under Articles 8, 9, and 22, the responsibilities assigned to the central authorities may be discharged by other public authorities, accredited bodies, and even in certain cases by non-accredited bodies or persons. This, of course, leads to the issue of costs and expenses in carrying out the responsibilities set out in Article 9. Article 32 sets out the restrictions on no one should to derive any improper financial or other gain from inter-country adoption. Only costs and expenses, including reasonable professional fees, can be charged. And the directors, administrators, and employees of bodies involved in an adoption shall not receive remuneration which is unreasonably high in relation to the services rendered. HCCH has recognized that donations, contributions, and cooperation projects should be separate from and have no influence on inter-country adoption, and has further recognized the direct and indirect risks connected to financial aspects of inter-country adoption. So recently, a working group has been established by HCCH on the financial aspects of inter-country adoption. The working group's first report was just released in June this year, and no doubt there will be further updates. But due to constraints of time, I will not be going into the report today. So now, finally, I come to the role of the courts in Hong Kong. In Hong Kong, an application for local adoption is to be commenced in the Family Court, which is a division of the District Court of Hong Kong. However, in relation to any applications concerning convention adoptions or inter-country adoptions, such applications must be commenced in the Court of First Instance in the High Court of Hong Kong. In other words, only the High Court in Hong Kong has jurisdiction to make any orders in relation to a convention adoption, or to make any order passing care and control of a child to a person authorized by the Director of Social Welfare with a view for his or her adoption. Whether it's a local adoption order or whether it's in respect of a convention adoption order, any application by a parent to revoke the general consent to the adoption, this also must be made to the High Court. For a child of whom the Director of Social Welfare in Hong Kong is the legal guardian, or the child is in his care, the child may sometimes, under our ordinance, make an application to the court to free the child for adoption and to seek dispensation with consent required for a parent or a guardian of the child. This is called freeing application, because in certain cases, sometimes the necessary consent is unreasonably withheld, or sometimes a parent cannot be found and his or her consent cannot be obtained. Then the Director of Social Welfare will then have to make an application to the court for the child to be freed for adoption. In one of my recent cases, in a freeing application by the director, I have followed the approach in England and Wales and the English authorities, and that there should be a two-stage process in considering a freeing application. First of all, whether the adoption is in the best interest of the child, and secondly, whether there are sufficient grounds to dispense with the consent, the required consent to the adoption. And in considering the best interest of the child, I've also followed the adoption checklist factors in the 2002 English Act, which is to consider the paramount consideration is for the child's best interest throughout the child's life. So this is quite different from the normal welfare checklist in relation to considering the custody or care and control of a child. And the court must also bear in mind, or the adoption agency must also bear in mind, any delay in coming to a decision for the adoption is likely to prejudice the child's best interests. The checklist factors have been set out there. I won't go through all of them. One of the matters I would also like to highlight is, of course, the child's age, sex, background, and any of the child's characteristics which the court or agency considers relevant. And another matter which the court has to consider is the relationship with the child has with the relatives and any person who is a prospective adopter with whom the child is placed, and with any other person in relation to whom the court or agency considers the relationship to be relevant. In a recent decision, upon granting the freeing application of the director, I've also imposed an undertaking to be provided by the director to continue to provide counseling and information to the child. The reason is this: usually when the director comes before the court to seek a freeing order, at that stage, the director usually has not actually identified the prospective adoptive parents, or whether the child is suitable for local adoption or inter-country or foreign or inter-country adoption. So there may be a gap of time before, because what the director is likely to do is to try to identify local prospective adoptive parents first before considering applications from prospective adoptive parents from another contracting state. So there may be a gap of time. And during this gap of time, sometimes a child may change his mind. So in a recent case, I have imposed an undertaking on the director to continue to provide counseling and information, and that in the event that the child has changed his views, his opinions, and this of course applies to an older child, then the director is to refer the matter back to the court. The role of the Social Welfare Department in Hong Kong. Of course, the Director of Social Welfare has been designated as the central authority in Hong Kong. All conventional adoptions are to process through the Social Welfare Department of Hong Kong or non-governmental organizations. At the moment, NGOs, there are 3 accredited bodies which the Social Welfare Department works with. They are the International Social Service, Mother's Choice, and Poland and Cook. And one of the speakers on this in this panel is Ms. Iris Liu, and she is from International Social Service. So I won't say anything more on this, and I will let her explain. I will just end with giving you some statistics. There have not been many. For the past 3 years, Hong Kong is receiving state. There's only 1 each year, and they are all from India. Outgoing, we have more. In 2020, you can see there are 10. The receiving state is the States. 6 of those 10 children have had special needs. You can see only 4 were under 5 years old. The rest, they were older. For 2021, there's 7 cases. 5 of them have special needs. And again, only 2 of them under 5 years old. 2022, we have more to the States, 15, 1 to Canada, 2 to Germany, 2023, 6 to Australia, 6 to US, and then 2 to Australia. And again, they are children with special needs, or they are older children. So with that, I come to the end of my presentation. Thank you very much.
Thank you. Thank you very much, Justice Chu. Please have a seat. Thank you for a very thorough introductory presentation. And now our next 2 guests will be sharing the regional perspectives. And let's start to welcoming Professor Elizabeth H. Agiling Pangalanga to the podium. Welcome. Sorry about the flashing on the screen just now. We're trying to fix the problems.
So I just press.
Actually,
Hmm? What do I press again? I forget. Oh.
actually, do you want a platform?
No, it's all right. It's all right. Good morning, everyone. First of all, I'd like to thank HCCH, represented now by Jerry, for inviting me today to speak during the Asia Pacific Week of 2023. I'm also glad to be here because last year it was the Philippines which hosted it, so it's good to be back. So I give today a short presentation on the implementation of the Adoption Convention um, with focus on the Philippines. So, children from Asian countries have historically accounted for a significant portion of intercountry adoptions. Recent data from 2005 to 2021 indicates that Asia has the highest number of children in intercountry adoptions, constituting 40% of the total adoption during this period. The Hague Convention, it's a long title, but the Hague Adoption Convention is in effect in only nine Asian countries. And this is what Christophe, Dr. Bernasconi said earlier, that we need more participation and involvement by Asian countries. So of these nine, four are members of the ASEAN, and these are the Philippines, Cambodia, Thailand, and Vietnam. I also looked up a study by Peter Selman, and this is found in the HCCH website. And here he studies 27 states. And one of the questions asked was the number of children that these states have matched in intercountry adoption. And we see that the highest is an Asian country, China, which during this period of 2004 to 2021 placed 89,647 children. So I will now go through the four ASEAN countries. With the limited time, I'm unable to take a look at all the Asian countries, the nine. But I will focus instead on Cambodia and discuss a bit longer the Philippines. No? So for Cambodia, they ratified the convention in 2007, and then they have a law on intercountry adoption passed in 2009. There were 3,696 children placed in intercountry adoption from 1998 to 2011. They suspended intercountry adoption in 2011, and I will discuss this in a while. The challenges and issues before Cambodia is the fraud and corruption in the ICA process. I hope that you can still read this. In 2001, the US banned adoptions from Cambodia in response to allegations of fraud and corruption, including Cambodian mothers relinquishing their children for monetary consideration. So this is the sale of children. And the US communicated that it would only resume intercountry adoption in Cambodia once it has rectified its internal adoption process to ensure full compliance with the Hague Convention. Then in 2003, the Netherlands, and later 2005, the UK followed suit and suspended intercountry adoption between their countries and Cambodia. And 2011, finally, there was a suspension by Cambodia of all intercountry adoption proceedings due to reports that some adopted children were not genuine orphans but were placed in orphanages due to extreme poverty, with the mothers believing that someday the children would be returned to them. And this problem was exacerbated by the collaboration of orphanage directors and local authorities who fabricated document falsely portraying the children as orphaned or abandoned. In 2022, however, last year, Cambodia resumed the processing of intercountry adoption applications upon implementation of stringent safeguards to protect the welfare and rights of children. The next country that I will look at is Vietnam, which ratified the convention in 2011, and they have their own law on adoption. Statistics show in the global ranking of the 27 countries that I mentioned earlier, Vietnam ranked 7 with 12,913 children. The main problems that they encounter have been kidnapping and sale of children. In 2003, adoption of children from Vietnam was suspended in the US. There was concern over kidnapping and sale of children, and this what they worried about was the spike in the number of children, um, and it raised doubt, sorry for the typo, about the voluntariness of birth parents to give up their children as required by US law. Prior to the ban, the trafficking of Vietnamese babies for foreign adoption was a lucrative business, with children fetching a price of $5,000 each. And this included children who were abducted, or parents who sold the children, or those who were born with the parents' intention of selling them. Third country is Thailand, which ratified the convention in 2004. They have several laws to implement inter-country adoption: the Child Adoption Act of 1979, Child Adoption Act of 1990, and then of 2010. And in the global ranking, Thailand ranked 12 with 5,743 children placed in inter-country adoption during this period of 2004 to 2021. There have been no reports on issues prevailing in Thailand regarding inter-country adoption. Sorry. Thailand's adoption laws require prospective adoptive parents from abroad to initiate their application through their country's central authority, in keeping with Hague Adoption Convention. Subsequently, this authority or agency undertakes the task of liaising with the competent Thai authorities. The adoptive parents must meet the eligibility criteria for adoption established by their own country's laws. But Thailand also requires that applicants must be legally married, and that generally they're not permitted to apply for adoption of more than one child. However, there are exceptions, and that is when they wish to adopt twins or siblings, or instances involving the adoption of children of the applicant's Thai spouse. The fourth ASEAN country in this study is the Philippines, which ratified the convention in 1996. You will note that we have an Inter-Country Adoption Act, which was passed the year before we ratified the convention. So that's RA, Republic Act 8043. But recently, there is a new law passed, Republic Act 11642, which is the Domestic Administrative Adoption and Alternative Child Care Act. The Philippines ranks 11 in the global ranking. From 2004 to 2021, we placed 7,309 children in inter-country adoption. And we have several issues that I identified and will discuss more closely now. So according to the Inter-Country Adoption Board, in their report of 2021, from 1995 to 2000, a total of 10,909 applications for inter-country adoption were submitted. Of these applications, only 9,919 were granted approval. And of those approved, 8,547 children were successfully matched. Now, the challenges and issues. One is the lengthy adoption procedure. Between 2016 and 2021, there were 1,999 abandoned children and 3,344 neglected children who could have been matched with loving parents and placed in permanent homes. Yet their placement remained uncertain until they reached adulthood, in which case most of them would not be adopted anymore. The Philippine Without Orphans, an NGO, estimates, non-governmental organization in the Philippines, estimates that the Philippines has approximately 5 to 7 million abandoned, neglected, or orphaned children, which accounts for about 1/6 of all children in the Philippines. Despite this, only 237 Filipino children are adopted each year, according to data from a Philippine nonprofit organization advocating for adoption. The second challenge is brought about by the unaccredited agencies participating in intercountry adoption. Rappler, a digital media company in the Philippines, reported in 2022 that 73% of the participating agencies in intercountry adoption, so that's 52 agencies, were actually unaccredited. Therefore, this gives rise to uncertainty in the quality and capability of the child caring agencies and child placement agencies involved in intercountry adoption. Third challenge relates to the proliferation of babies being sold online and adoption trade. The Philippine Center for Investigative Journalism released a report in 2003, June, very recently, highlighting the online sale of Filipino babies. They pointed to the existence of several Facebook pages of Filipinos offering children for adoption. In an earlier report, showed that infants are traded online for $100 to $500, and the price even goes up to 1,000 for children considered beautiful or those of mixed race heritage. Now, the legal framework in the Philippines is there. We signed the UN Convention on the Rights of the Child in 1990. We ratified the Hague Abduction Convention in 1996. And as I stated, even the year before that, we already enacted Republic Act 8043. In response to the persistent challenges associated with lengthy adoption processes, Philippine Congress enacted most recently Republic Act 11642. Consistent with the subsidiarity principle in the Hague Abduction Convention, um, this law says that domestic adoption is still the priority to ensure that the child's identity and cultural heritage are preserved within the Philippines and that the intercountry adoption is the last resort. Again, consistent with the convention. Now, I will discuss a bit what's in the new law. The fundamental adoption process for intercountry adoption remains unchanged. However, it has a notable impact rather on intercountry adoption because the ICAB, the Intercountry Adoption Board, which used to process all intercountry adoption applications, has been transformed into the NACC, the National Authority for Child Care, which operates under the Department of Social Welfare and Development. With domestic adoption now an administrative procedure, no longer a judicial procedure, the identification of and matching with available parents for a child has become faster. And therefore, the assessment of a child's availability for intercountry adoption is also expedited. So, the main change here in this law is that it made domestic adoption administrative instead of judicial, with the hope that this will expedite the procedure. And if so, then children who cannot be matched in the Philippines will now be available for intercountry adoption. However, the Philippines does not limit its interaction with countries that have ratified the Hague Convention. The legal framework allows participation in the Philippine Intercountry Adoption Program by foreign adoption agencies from both contracting and non-contracting states. It requires the prospective adopters, however, to agree to uphold the rights of the child as embodied in the conventions and Philippine laws, and that they must come from a country with diplomatic relations with the Philippines and whose government maintains a similarly authorized and accredited agency, and that adoption is allowed under the applicant's national laws. Concluding observations. First, that global data reveals a declining trend in intercountry adoptions. The number of adoptions worldwide in 2013 was 3 times lower than in 2003. Additionally, a significant portion of the internationally adopted children have special needs. And special needs here is defined as children who are older. Again, the preference is to adopt children who are really young, babies, infants. No? And I guess this has to do with the applicants wanting to feel that they are the real parents, or that they have the power, the opportunity to mold this child the way they want to. If the child were older, then they think that they have no say or little say in the way the child will grow up. The presence of siblings, again, there is the goal is not to separate siblings from each other, or we have children with disabilities. The decline in intercountry adoption is attributed to several factors. On one hand, we can look at this as a positive development. It suggests reduced instances of child abandonment or parental relinquishment, so it's good. On the other hand, the decline may be linked to persistent misconceptions about adoption, the complex and often expensive adoption process, and receiving countries' growing apprehensions about reports of corruption. As we review the challenges that the four ASEAN countries face and what their governments have done, it's important to go back to the provisions of the Hague Adoption Convention and the principles reflected in these provisions. One, the best interest of the child, which requires that no sale, abduction, or trafficking of children be done. We find this in Article 1 as one of the objectives of the convention, and also in Article 8, that all appropriate measures to prevent improper financial or other gain be ensured. Also, the goal of the convention to for the child to have a permanent and stable relationship, a permanent and loving home. We see this in Article 2, number 2. The convention covers only adoptions which create a permanent parent-child relationship, as well as in Article 4, which requires that the consent of the parents be assured, and that the consent is given only after counseling, so that it is clear to the parent giving up their child, as well as to the one applying to be an adoptive parent, that this will be a permanent relationship. Likewise, the need for qualified and professional government recognized bodies. As I pointed out earlier, it was reported in the newspapers in the Philippines that there were 52 agencies which were not accredited, and yet were involved in intercountry adoption. So there must be closer supervision of this. Article 10 of the convention requires accreditation, as well as Article 11. An accredited body shall be directed and staffed by persons qualified by their ethical standards and by training or experience to work in the field of intercountry adoption, and be subject to supervision by competent authorities. So we see that there is need to go back to these provisions to make sure that the problems and challenges that have arisen in the four countries that I identified will be met. So this is the end of my presentation, but my last point is that by October 1, I will be joining the ASEAN Commission for Women and Children as a Philippine representative for children's rights, and I hope to bring my advocacy in HCCH to my work there, again in the hope that there will be greater involvement by ASEAN countries. Thank you very much.
Thank you. Thank you, Professor. Please have a seat. Thank you for a very informative presentation. Now let's continue talking about more on regional perspectives. Let's welcome Ms. Iris Liu to the stage. Please take the podium.
Good morning, ladies and gentlemen. Today I will share the practical experience of adoption under the guidelines of convention. This adoption convention established in 1993. The objective of the convention, first of all, should be ensure the to adoption take place in the best interests of the child and with respect for their fundamental rights. The second objective is to establish measures to prevent child abduction, sales, and trafficking in adoption through cooperation with the contracting states to ensure the recognition in contracting states for adoption made in accordance with the convention. We believe that children should grow up in a lovely family environment, and permanency is crucial for their well-being. According to the principle of subsidiarity, a child should be raised by his or her birth family or extended family whenever possible. If not possible, other forms of permanent families care in the country of origin should be considered. If all else fails, in-the-country adoption may be considered. Now I'll share some scenarios and challenges in Hong Kong. What we mentioned that we have to find the local adoption first. So regularly, we, Social Welfare Department, and 3 accredited adoption agency will have regular matching panel. At least once a month, we will have working together and check all the available local families and also the children in Hong Kong available for adoption, and all through the procedures. Sometimes we will discuss day and night to find a fit family for the local adoption. However, many adoptive families prefer younger and healthier children. This preference poses a question: should we promote local adoption more or not? If yes, how to ensure everybody have access to right information? Another challenge is related to the birth families of these children. We offer support families, a support service to birth families with the aim to reintegrate children to their care whenever possible. But the effectiveness and dedication of temporary service provider play a crucial role in planning for the long-term placement of these children. Due to various reasons, some children end up in temporary settings for extended periods, which is far from ideal. The consent of birth parents is crucial requirement for the adoption process. Unfortunately, in some cases, parents only sign off their children after a long period of time. The children become elder, and this poses challenge, as it is very difficult to find suitable adoptive families, both locally and overseas. Consequently, both the children and their adoptive parents may encounter difficulties in adjusting to each other. Seeking consent from the birth or legal parents towards adoption is more difficult if they are not living in Hong Kong. We try all the means to find them to get their view, including posting the tracing advertisement in the local newspaper. But the process is time-consuming, especially considering that different countries have different requirements for tracing advertisement. Even if we locate the birth parents or legal parents, they may be unwilling to be involved in the sign-off procedures. In the absence of the consent, it becomes necessary we have to obtain the court order. Here comes the concern of time and cost again. Another challenge in Hong Kong adoption is the views of the children. In Hong Kong, we place great importance to considering the view of children. We try to understand their perspective and feeling. However, we recognize that some children may find deep attachment to their foster families or caregivers without proceeding with a long-term care plan, including adoption. We encounter some children, age 8 or above, express their unwillingness to being adopted, which can ultimately result in the adoption process may be unable to proceed, even though we found a suitable adoptive family for them. With the question, how old and how the children make their own decision that affecting their whole life, But at the same time, we have to respect the wish and feelings of the child. So at this time, we have to ensure alternative arrangement may need to be explored to ensure the child's well-being and stability. Another discussion is whether we have to think about the appropriateness to transitioning foster care to adoption. Foster care family, although it's temporary, should not prevent the child to return to their birth families or being adopted. In Hong Kong, there's no fostering adoption in general, but some cases, taking into consider the best interest of the child, we maybe make that kind of special arrangement. The key point, we have to prevent the improper financial or other gain in connection with that adoption. Here, I want to highlight some, this is not work, challenge in the outbreak of COVID-19. At that time, most children's residential home and hospitals were not open to visitors. It made the adoption social workers could not visit the children to prepare them for adoption. At the same time, the overseas families could not come to Hong Kong to complete the adoption procedures and receive the adopted child, as the border was closed. Luckily, we have social workers of ISS Hong Kong escort 2 boys from Hong Kong to the US, enable them to reunion with their new families, including me. I escort a boy from Hong Kong to the US in August. At that time, you see, even a dog would wear a mask. I have to go through all the difficult prevention measure and obtain the travel documents. After returning Hong Kong, I have to be quarantined for 14 days. Here, so another social worker of our agency, ISS Hong Kong, escorted another boy from Hong Kong to US in the same month. Definitely, it was not easy, but most delighted part that we can witness a boy joining their permanent families. Due to the closure of a government office and courts, the adoption procedures face delays. In response, our dedicated social workers provide additional support to ensure the successful reunion of our children and their adoptive families. To conclude, we have to ensure the child's welfare takes preference. It is crucial to prioritize their best interests and well-being during the adoption journey. In collaboration with our agency partners, we will actively explore all means to achieve this shared goal. To being informed and based on most recent guidelines, it is important to familiarize oneself with any new guidance, travel restriction, and adoption procedures that have been put in place. To enhance pre-adoption education and preparation, focus on aspects such as the child's background, culture, and potential challenge they may encounter. Utilize pre-adoption education programs and available resources to embrace the unique aspect and evolving condition of international adoption. In times of uncertainty, I think patience and flexibility are key. The adoption journey may not always go as planned, but we must be ready to adopt any different circumstances and demands. Last, I have to say that we and all the agency and our social workers have the view that let us join hands and hearts in creating a loving and nurturing environment for every child where they can grow and embrace with the warmth of forever family. Thank you for your listening, and let's continue working together to ensure the adoption is carrying out in the best interest of every child. Thank you.
Thank you. Thank you so much, Ms. Liu. Thank you for your great presentation and all the meaningful work you've been doing. Thank you so much. And may I just invite Justice Chu, please, we can have a seat in the center of the stage. Yeah, we have a name tag for you. Thank you very much. Is your name tag? Let's have a look. Yes, thank you very much. So, ladies and gentlemen, it's time for the Q&A. we encourage everyone to engage actively into this session. And please feel free to raise your hand if you have any questions for our three gorgeous ladies on stage. Please just raise your hand. This gentleman, please.
I'm thinking if there is a conflict between the law of the country of origin and the law of the receiving state regarding the adoptability of the child or the eligibility of the adoptive parents. So which law shall apply? The law of the origin or the law of the receiving state? You know, just now I listened to your presentation. I know, you know, there are so many things for cooperation between the central authorities, and also you said some issues that should be governed by the law of origin, and some issues should be governed by the law of the receiving state. But when there are conflicts between the two laws for the two specific issues, how to resolve this? Are you using the double standard or are you using which state law? Thank you.
Justice Chu.
Is this on?
Yes.
Well, first of all, before a child can be sent abroad to, from Hong Kong's perspective, before the child, closer. Can you hear me now? Excuse me. Yes, before a child can be sent abroad for the purpose of adoption, there has to be an agreement for the adoption between the two states. And the agreement, of course, I believe, from Hong Kong's point of view, if after investigation, there will be very detailed home study reports and social welfare reports of the prospective adoptive parents. And if the state of origin, I assume that if they see anything that they are concerned about, then the state of origin may not enter into that agreement with the receiving state. So that is one way of dealing with the issue. And the other way is, of course, as I have said, if the country thinks that according to their laws, they will not recognize the adoption under public policy grounds, then this is still possible under the convention. You're shaking your head and waving your hands, so I'm not quite sure this is the person who asked the questions.
The destination of the child is the receiving state, right? So it seems the adoptability of the child shall be governed by the law of the receiving state, right? Because the final destination of the child is the receiving state. However, on the other hand, look, the child is from the state of origin. It seems this issue shall be governed by the law of the state of origin. So that is the dilemma why I'm asking the question. The same to the eligibility of the adoptive parents. Thank you.
Sorry, perhaps I will let Iris also add her own comments.
Yes. The state of origin will determine, will determine whether or not a child may be adopted. Because for instance, in the Philippines, this is the adoption of a Filipino child. And therefore, who determines whether this Filipino child can be adopted, whether domestic adoption or inter-country adoption? Then it's none other than the Philippines, which is the state of origin. On the other hand, the qualifications of the adopter will be determined by their own laws or the receiving state. Because in the first place, if you recall, the process is that they file their application in the state where they're from. And it's that state which determines whether they are qualified to adopt. If they're not, then it's not even going through.
But suppose if the adopter can satisfy the law of the receiving state, but cannot satisfy the law of the origin.
It will be,
See my point?
yeah, but I think that case will not be happen under the proper adoption procedures. We mentioned that going through the proper adoption procedures, we have to complete all the requirement before.
Double standard, right? It means it has to satisfy both standards.
If you cannot complete the proper procedures at the country of origin, by all means you put the child to other countries, then we sometimes will say it's a child trafficking because they cannot obtain the proper legal procedures before they leave the country of origin. That's what we encounter some cases. The children, by all, some kind of means they travel to Hong Kong or go through to other countries, but they didn't complete the proper adoption procedures. There's a lot of complicated procedures that we have to going through.
Well, perhaps I just add again, I won't call it double standards. I mean, as described by Iris and also Professor here, that for the receiving state to approve that the application of the adoptive parents, that application must comply with the law of the receiving state. And as far as the state of origin is concerned, in order to free a child for adoption, as I have said, the freeing applications, again, the state of origin, the central authorities must satisfy the law of the state of origin in order for the child to be freed. They will have to come to the court to get the child to be freed for adoption. So it's only after the child has been free from adoption, then they will match the child with prospective applicants from another country. And once it's identified, then there will be an agreement for passing the care for the adoption to take place. That, I understand, is the procedure. I hope it answers your question.
Sorry,
Obviously,
did the ladies answer your question? I'm so sorry, I'm not qualified to join the ladies. Okay, please, one more question, please.
Thank you, speakers, for the presentations. I don't have the question, but actually I have some comments on a presentation of Professor Elizabeth from University of Philippines. I heard in your presentation you have some information about Vietnam adoption situation. Actually, I am not the center authorities of the adoption convention, but I can provide you some updated information because after Vietnam joined the adoption conventions in 2020, and we also have the law on adoptions in 2010, and from that time to now, we improved a lot of activities to effectively implement the conventions. And you may know that last year in Asia Pacific Week in Manila, the Vietnam delegation had a presentation to share our good practice in implementation of the adoption conventions. And for Vietnam and Americas, we resumed our cooperation on adoption since 2013. And last year, the special advisors on children of America visits our central authorities, and she were very highly appreciate our achievement in this area. So if you need any more information of Vietnam, I'm willing to connect you with my college and provide you updated information. Thank you.
Thank you very much. Thank you for your statement. And do we have one more question? That lady, please. Sorry.
Okay, thank you for the very wonderful speech. I do have two questions. First one is considering actually in family matters, we have so many different traditions and family cultures in different contracting states. So I want to know, like, under the convention, from the convention perspective, how do we actually in practice balance or filling this gap of the traditions? For example, for same-sex couple, because like Justice Chu mentioned, in some countries, same-sex marriage is recognized, but in other contracting states, like in China, same-sex marriage is not recognized. So if a same-sex couple want to adopt a child, maybe it will be refused, like in China. So how do we do you have a mechanism or in practice like we have something to filling this kind of cultural gaps between different contracting states? And I have one more question is also about practicing matters, because we have judges and also practitioners from Hong Kong here in the panel. So I want to ask, in practice, how do the central authorities communicate with the judicial body? Because we need to, you need to work together to make sure an adoption is satisfy the best interests of the child. So do we have, like in Hong Kong, is there any well-established mechanisms to make sure this process goes smoothly and you work like in a very smooth way? Yeah, thank you.
So who would you like to choose to answer the first question? Justice Chu?
Well, perhaps I'll take the second question because there's not actually that much discussion between the Social Welfare Department and the courts. So the only time when the courts get involved in an adoption, a convention adoption case, is, as I said, as I have mentioned, that when there is a freeing application. So it's only when the director has a child with no, all the required consents, they have not been able to obtain all the required consents, and they will have to make an application to the court to free the child for adoption. And this means freeing the child for both local adoption and convention adoption. And that's the only time that the court will be involved in first contact the court will have. Then, of course, if when the prospective parents have been identified in a convention adoption, the child will then have to be taken out of Hong Kong to the receiving state. And that is just what Iris has described and explained. And you have looked at all her beautiful photographs. And they will then come, they will have to come to court to obtain an order for passing care, which means to allow them to take the child out of Hong Kong to a receiving state. So that's really the only time when the court gets involved. So when the court gets involved in the first stage, which is the freeing application, that is the time when the court can consider the child's best interests. And we will look at, of course, all the factors. As I have said, I've identified those factors, which include the child's cultural background. And also, even at the stage of passing care, there have been cases which the court are not satisfied, that we will not make an order and then asked for director for further information and also for further reports on the child. I recall there's one case that I refused to allow, I refused to grant the passing care and the freeing out applicant order because I felt that the child was an older child. I think he was about 6 or 7 years old. He just refused to go to, I think it was the States. He didn't want to go out of Hong Kong. He became very attached to his foster parents. And I found a case in England, which I followed, which I decided that in the end, that maybe allowing him to stay in Hong Kong would be better in his interest than to send him abroad.
Thank you very
Perhaps,
much.
Iris can answer your first question.
For the question about the connection with the central authority in Hong Kong, I think for the connection with them is in two levels. One is the agency level, because in Hong Kong, according to the audience, we become an accredited adoption agency. We have to go through annual assessment. So every year, the officers from the central authority, you come to our office, you check all the files and check case by case whether we follow through all the requirements of adoption audience and also the convention. This is first, recently, the central authority moved to the same building of our office, so it's more closely monitoring our work. And the other thing is the case by case level. I think every case, before matching the child for overseas adoptive parents, and during the adoption process, and after the adoption, every step we have to discuss with the social worker of the central authority and go through all the necessary legal requirements. So it is bit by bit and all very thorough understanding. And after pasting them to overseas, we have keep regular post-placement report, checking whether the children and the families adjust very well. It depends on different countries. Some countries require 3 post-placement report, other countries will require 6. After fulfilling all the requirements, and then they will finalize their adoption in the receiving countries. I think ISS taking involved the intercountry adoption almost 65 years. Luckily, we didn't have less than 5 failed cases. And I think it is quite good practice in Hong Kong to make sure every adoption is in good practice. Thank you.
Thank you for sharing the cases. So I saw this gentleman just raise your hand, please. But can we keep this question short? Thank you.
Thank you so much. Big thanks to the panel. I learned a lot. I really appreciate it. And I've got one very short technical question for Justice Chu, actually, just about adoption and ratification of the convention in Hong Kong. I think you'd mentioned that it came from the central authorities, mainland authorities, in terms of the direction for the adoption of the convention, but then it sounded like the actual ratification was through local laws. So I was just interested in what the process was for the Hong Kong ratification. Thanks.
Yes, as I have said, because we're part of People's Republic of China, so we cannot be, Hong Kong cannot be of itself a contracting state. So after the central People's Government has decided that the convention will apply to Hong Kong, then we will have to look at our domestic laws. And what we have done in both the adoption convention and also the adoption convention is to incorporate it into part of our local laws. We have a schedule setting out all the relevant articles. So that's why I've also earlier mentioned that not all the articles have been incorporated, only those which are applicable to our level, because some of the articles may require cooperation at the state level. And since we're not a state, we cannot be a state, and therefore that's the only way we can deal with it. So to incorporate, basically, simply to incorporate it into our domestic legislation.
That's great. Thank you so much.
Thank you. Let's put our hands together for this gorgeous panelist. Thank you so much. Thank you very much. All right, ladies and gentlemen, let's move on to our next topic, which will focus on the 1980 Child Abduction Convention and the 1996 Child Protection Convention. And we're very honored to have the following distinguished individuals join us on stage. Let's welcome the Honorable Justice Victoria Bennett, Judge at the Federal Circuit and Family Court in Australia, and Honorable Justice Amy C. Lazaro Javier, Associate Justice at the Supreme Court of the Philippines. Welcome to the stage. And Mr. Stephen Yao, GBS JP, Chief Executive of the International Social Service Hong Kong Branch, and Ms. Yet Ngung Fu from YN Fu and Partners Malaysia. Welcome, ladies and gentlemen. Please have a seat. So at the beginning of this session, let's firstly welcome the Honorable Justice Victoria Bennett to deliver the introductory presentation. Please take the podium.
Adrian, do we have a...
Thank you, Madam. Thank you for the introduction. Greetings from Australia. Thank you to our hosts and to the Permanent Bureau for inviting me to present today. These are my own views and they don't, in fact, could I just raise the fact that this is the wrong PowerPoint? We have not the correct PowerPoint. Have we got the one from yesterday? How about we just go with it? All right. Okay, so we'll do the best that we can. Thank you very much. I noticed that it wasn't the correct PowerPoint because on the one that I did, I made a point of saying how delighted I was to be here with so many people who I have things in common with that I hadn't met, and that it was very nice to be with my old friends and my new friends, and that I found the student ambassadors to be quite inspirational. Nothing has been too much trouble for them. They have been so kind in telling us where to go and helping us and supporting us. And it occurs to me that in such a forward-looking seminar or conference as we have been having in the last 4 days, they are really the future. And I wouldn't be surprised if they end up sitting where we are sitting now in some years' time. So thank you to them. I will go over just flick through some slides that I won't use in this particular talk. When dealing with the children's conventions, there are certain common features. They each contain particular terms, which are specific legal terms such as habitual residence, rights of custody, wrongful removals, and measures. Very briefly, habitual residence is the connecting factor for the children's conventions, and it's the country in which the child actually belongs. It's different from nationality or citizenship. It's the country where the child essentially belongs and where the information concerning the child's welfare is likely to be found. Rights of custody is a right to determine in which country a child will reside. Authorities, the conventions don't talk about courts, they talk about authorities. Authorities can be government authorities or they can be courts. Measures are actions that are taken by authorities, so they can include very commonly orders of courts. These expressions have autonomous legal meanings and must be interpreted consistently by all the contracting states for the conventions to actually work. The Abduction Convention is a forum selection treaty. It doesn't determine jurisdiction. It provides for the prompt physical return of a child to the child's state of habitual residence, which I'll call the home state, because the courts in the home state are best placed to determine what's in the best interests of the particular child. The Abduction Convention applies to children up to the age of 16 years. The Protection Convention applies to children from birth until they reach the age of 18 years. There's a specific reason for the discrepancy in ages. Now, when I first started to do Hague work, I noticed that this was many years ago, it was in Sydney, on the desk there was some pictures of elephants, and I asked then William Duncan, why the elephants? And he was wearing an elephant tie. And he said, oh, elephants in habitual residence. And I said, what do you mean? He said, well, elephants are just like habitual residents, very difficult to describe, but you know one when you see one. And it's stayed with me. So a theme of my talk has generally been elephants, and then also from Australia, chocolate, because we have these little chocolates that have very unusual, difficult to describe, that's right, difficult to describe animals, but you know them when you eventually see them. More technically, habitual residence isn't defined in either convention or indeed in any of the Hague Conventions. A popular description, but not a definition, is habitual residence is a place which reflects some degree of integration by the child in the social and family environment. Shared parental intention is to reside in a place is relevant, but not a necessary prerequisite to the establishment of habitual residence. You'll appreciate that many of these cases happen when parents have separated, are separated, and parental intention was in accordance with English and Australian law, given significant weight. So where the parents have last thought that they will reside as a family was considered to be the state of habitual residence. More recently, Europe has gone another way and England has gone another way, and the weight to be accorded to parental intention has decreased. Central authorities under the 1980 Convention are really the most important part of it. Without a functioning central authority, you don't have a functioning convention. Now, even though you may not be part of a central authority, if you're going to deal with the convention, it's good to look at the duties and expectations on central authorities, and the Permanent Bureau has actually published a guide to good practice for central authorities, which I'd commend to you. The core requirement of the Abduction Convention is that the process must operate expeditiously. It's a hot pursuit remedy designed to replace the child into his or her home state so parenting arrangements can be worked out either by agreement or by an authority such as a court, or just allowed to occur. It's important but not essential that both parties will have access to the courts in that country. The procedure for activating the convention is that a left-behind parent would contact the central authority in his or her state, fill out a form providing a lot of details. If the central authority is satisfied that the child has been wrongfully removed, and that's a term of art, or retained in another country, which is also a contracting state, to the convention, that central authority will transmit the request for return to the other country where the child is thought to be. If that central authority considers that the removal or the retention is wrongful, then they will take proceedings to have the child returned to the original contracting state, or empower the requesting parent to do so privately. Removals and retentions are wrongful, but they're not unlawful. None of the children's conventions criminalise any activity at all. Only contracting states criminalise activity. It's not part of the conventions that people should be punished for wrongfully removing or retaining a child. It's simply that the child should be returned unless there's an exception that applies. The abduction convention has to have entered into force between the contracting states before you can have a return from one state to another. The removal and retention must be wrongful within the meaning of Article 3. A removal or retention is considered wrongful if it's in breach of a person's right to determine where the child should live. So that's another autonomous legal term. Retention and removal are mutually exclusive concepts. So retention occurs when, for instance, a father may agree to the mother taking the child to another country for a holiday. The child and the mother leave the country, and that's not wrongful. But when they don't come back when they said they would, that's wrongful. So that's a wrongful retention. A wrongful removal is when there's no consent to the removal in the first place. Once a removal is characterised as wrongful, it's necessary to determine whether the application for return is made within 12 months of the date of the removal or the retention. It's important because if the removal or retention is within 12 months of the date that the application's filed in the state where the child is, then the return has to be prompt, unless an exception applies. If the application's brought more than a year after the retention or the removal, then there's another hurdle for the applicant to overcome, and that may be if the taking parent says that the child has become settled in the new environment. Now, that's reflective of the fact that this is a hot pursuit remedy, that there is no investigation in the beginning into the welfare of this particular child. It's considered that if you can get onto it soon enough, you take the child from where they came and put them back there, and then the courts or authorities in that country will look after the child and ensure that the parties can reach some accommodation or some arrangement that is in the child's best interests. The 12 months runs from the date of the wrongful removal or retention and not from the date on which the left behind parent might have realised that the child had gone, or alternatively found where the child was to be able to know which country to ask to return the child. There have been, in the past 20 years, certain countries, including America, who tried to introduce tolling so that it wasn't, the 12 months didn't start until the parent knew where it was, but that's not part of the international law at the moment. The returns to the requesting state and not to the holder of the rights of custody or the applicant, and a return does not have to be to where the child used to live. Now, there are exceptions to return. The first is if the left behind parent wasn't exercising rights of custody or the removal or the retention was not in breach of those rights. The second is that the requesting parent or left behind parent consented or subsequently acquiesced to the removal or the retention. In that case, the child won't be returned, or the child may not be returned. Third, the return would expose the child to a grave risk of physical harm or psychological harm, or otherwise place the child in an intolerable situation. This is the exception to return which has probably occupied most of the most of the courts which have considered the application of the convention. It's called the grave risk of harm defence, in short, and this is where you deal with the incidence of domestic violence or family violence in its very many and toxic forms. The fourth is if the child objects to return and is mature enough to have his or her views taken into account. And finally, there's an exception to return if a return would be contrary to fundamental principles of freedom and human rights of the state where the child actually is. That's a very unused part of the convention. Now, the exceptions to return, if the court is satisfied that one or any one of those exist, then has a discretion to refuse return. If the exceptions don't apply, there is no exception and the child has to go back. But if there is a discretion, if an exception applies, the court has a discretion to refuse return. The 1980 Convention does not specify what would inform the exercise of the discretion. In common law countries, the exercise of the court's discretion to refuse return can be informed by the best interests of the child at that stage. Likewise, in determining whether or not, for instance, a child would be exposed to a grave risk of harm, or to exercise, whether it's appropriate to exercise the discretion to refuse return, the court can consider conditions to return. I've put a list there of matters that I think it's important to take into account when setting conditions. These are conditions which are going to attach to how the child will be returned and the circumstances to which they'll be returned. This is the sort of this is the time you would consider, for instance, if a requesting state had, in the absence of the taking parent and the child, found that the taking parent, deal with them stereotypically, the mother had been convicted of having kidnapped the child and therefore faced criminal penalties immediately upon returning. That's something that you'd look at in conditions, and you would say, well, the child isn't going back unless, you may say, I would probably say, the child isn't going back unless we know the mother isn't going to be locked up as soon as she gets off the plane. Those sorts of things. Conditions must be simple, they must be realistic, they must be necessary and proportionate. Some years ago, a judge gave me a case right at the last part where he had decided the child needed to be returned, but the mother was seeking a lot of conditions. And one of the conditions was that she had a car. And I said, well, madam, do you have a licence? No. Madam, do you know how to drive a car? No. Well, I don't think you're going to get a car as a condition of returning to the country. So those sort of practical matters. Conditions must not frustrate the operation of the convention. You would never make a condition that could not be complied with, because that's just a backdoor way of not returning the child. Specialised Hague mediation is very important. It's now an accepted feature of Hague return cases, although it's not mentioned specifically in the convention itself. It is a duty of the central authority to consider amicable returns, but mediation has proven to be an excellent component in Hague return cases because the parties get some control and can, even if they can't decide whether or not the child should go back, they can decide what's going to happen if the child does go back or if the child doesn't go back. Because you're necessarily dealing with a child who probably is going to have, if the child doesn't go back, you're going to have a child with parents in 2 different countries. And if the child is sent back, you're going to, at least in the first place, have a child with one parent who wants to go to another country, either to live, to relocate, or to go there regularly for holidays. There's a book published by the Permanent Bureau called A Guide to Mediation, and I commend it to you. There are international organisations. Reunite International is a particularly prominent one, that deal with specialised Hague mediations. There are several principles for good practice for contracting states with the 1980 Convention. Experience shows that the 1980 Convention is probably most effectively implemented in a country where you have a concentration of jurisdiction. That is, within a country you would only have one court or one group of courts dealing with convention cases. It's difficult for a judge who's never seen a convention case before to take all of the necessary principles on board. Some of it's counterintuitive if you've done family law work. And so the trend is to try to concentrate jurisdiction. A comparison would be in Germany, they had difficulty implementing the convention consistently, but then changed so that all convention cases are heard by courts which are geographically close to an appeal court. And now Germany is considered to have a very high rate of compliance with the convention. In the United States of America, there are about 35,000 judges who can hear a Hague case. So you don't get any degree of specialisation. There's the International Hague Network of Judges, of which I'm one. I hope my slides have been sort of up with what I've been talking about. That's the three Hague Network judges for Australia. That in the middle is our Chief Justice, who's the head of jurisdiction for all the family law in Australia, and Justice Williams, who's my colleague in Melbourne as well. I'm pleased to say that Bibi Chu, who we've heard from, is the network judge for Hong Kong and has been for many years. The next thing that I'll deal with is, Hague Network judges have a body of law around them themselves. There's a guidance published by the Permanent Bureau, and one of the main features is that they can communicate with each other under certain conditions of transparency and usually consent about practical matters to do with the case. I find this a particularly helpful text, so I've put it in the slides for you. Otherwise, the Permanent Bureau has published texts, guides to good practice on a number of features of the Convention, and I commend those to you as well. So going on to the 1996 Convention and more elephants. When elephants fight, it's the grass that suffers. That's pretty much what children have to put up with. The 1996 Convention aims to improve the protection of children in international cases. It's intended to remove legal and cost barriers confronting families who live across international borders and to facilitate families, even intact families, to move from one country to another without having to re-establish the legal rights that pertain to children when they move. The Protection Convention applies to a child and also to a child's property. I'll deal here mainly with the child than with the property, but an example of a child's property being dealt with under the convention that came into my court some years ago was that a mother and a child were Australian and had lived in Australia. The father had resided in France. The child and the mother used to spend some months each year with the father in France. He died. The father also used to spend time in Australia. The father died and he left certain property, but the property could not be dealt with by the French courts. And the French court sent a request under the 1996 Convention for me to transfer jurisdiction to the French court to deal with the property, which it was easy to see that it should happen. I did. The French court made the order, which could be enforced in France. The child got the money, which was eventually transmitted to Australia. objectives of the convention are pretty much as stated there in that slide: to avoid a conflict or standoff between courts in two different countries. So there's an easy way of determining which court should have jurisdiction, and generally it's the country of the habitual residence of the child. The convention also determines what law will apply in a case, and it's generally the law of the country. Generally, countries apply their own law, except in cases of exceptional circumstances. It deals with parental responsibility and how that moves with a child, and it provides for recognition of measures or orders or rights between contracting states. And it requires cooperation between central authorities. Again, you must have a functioning central authority if you want a functioning 1996 convention, although perhaps not to the same point as with the abduction convention. With the 1996 convention, it's not essential that the central authority is involved in every case, but if you don't have a functioning central authority, you're probably not going to have much awareness of a 1996 convention in a country. There's an inclusive list of measures that come under the Protection Convention, and that's what they are. There's a list of exceptions or matters that don't come under the convention, and they are up on the screen. For instance, trusts or succession, social security, immigration, maintenance obligations. You might have heard about Brussels II and Brussels II revised. That's a European convention or agreement, and it very closely follows the 1996 convention, because when the 1996 convention was first considered by the Hague Conference and it was concluded, it coincided, unfortunately, with Europe coming under the European Union, and they had difficulty signing on. They realised that they couldn't sign on, or they made a decision that they couldn't sign on, but they also didn't want to forego the benefits, the obvious benefits of the 1996 convention, so they made their own. Now, in Europe, they have Brussels II, the new Brussels arrangement as between European countries. They also, with non-European countries, have the 1996 convention. The 1996 convention, I won't suggest to you, is an easy read. It isn't an easy read, and if you try, you probably won't understand it on the first 3 or 4 reads through. I haven't got time to go through every part of it, but what I'm going to do is tell you a bit of a story about a family, and we'll see how we can use it. The other thing is that when my colleague, my former Chief Justice, John Pascoe, comes to talk about the Protection of Adults Convention, it very closely follows the 1996 convention. So let's have a look at the story. Jack's 6 years old, and he lives with his Australian mother in Australia. Jack's father's Moroccan, and when his mum and dad separated, Jack's dad went to live and work in London. Jack's mother was refusing to let Jack go to London to have access with his father, and his father wanted orders entitling Jack to come to London for access. Australia, England and Morocco are all parties to the Protection Convention. How do I get that to go up? I'll just see. Can we make that slide just go up so I can see what's on the bottom of it? Oh, lovely, thank you. Right, England, Australia and Morocco are all parties to the Protection Convention. Article 5 of the Convention provides that the state of habitual residence of the child has primary jurisdiction. Jack's habitually resident in Australia, so Australia has primary jurisdiction, and his dad would have to make an application in Australia for access to Jack in London. If Jack's dad went to the English courts and tried to bring an application, they would know about the 1996 convention and refuse to deal with the matter if the mother objected to it. So that's how you cut down the competition of jurisdictions. Now, Mum and Dad fought a lot when they were together, and in fact Jack thinks that the only person Mum has ever fought with more than him was his dad. Mum didn't ever hit the father, but she does actually hit Jack when she gets cross, and sometimes she hits him really quite hard. Jack hadn't told his father anything about being hit by his mother, but when he went to, eventually Jack's dad did get time with Jack in London, and when he went there, he did tell his father what had happened with his mother. The orders pursuant to which Jack would go to London had to be drawn in a certain way, and the convention allows them to be drawn so that you can use, an Australian court can use the English law and express the orders so that they will be easily applied in England. That's one of the attributes of the convention. In order to, once an order is made in a convention country, it's recognisable in another convention country by force of law. So as soon as the order was made in Australia, it was recognised in London without anything else happening. However, for the purpose of enforcement, and Jack's mother wanted to make sure that the order would be enforced, she wanted it registered for enforcement. That's one more procedure that has to be undertaken, but the convention requires that each contracting state have a swift and simple mechanism or procedure for making an order enforceable. So when Jack gets on the plane to go to London, there's an order that the mother knows is enforceable in London to get him to come back at the end of the contact time. But he didn't come back because Dad changed his mind and decided not to send him back. And that would be a wrongful retention under the 1980 convention. And Jack's dad makes the application under the abduction convention. He raises the concern that Jack had about being hit by his mother and says that if I return Jack to Australia, that will place Jack in a position of, or expose him to a circumstance of physical and emotional harm. The proceedings don't go as quickly as England normally takes the proceedings, and 2 months later the mother gets offered a business trip to go to London, and she takes it because she wants to see Jack whilst she's there. So what would happen under the 1996 convention is that the English courts would then have a jurisdiction to deal with the matter urgently because the mum's there and wants to see Jack. Now, you'd be worried if you were Jack's dad because whereas he'd abducted the child in the terms of the 1980 convention, he doesn't want the child being reverse kidnapped and being taken back to Australia. So the English courts would have a subsidiary jurisdiction under the 1996 convention, which would enable them to do things like say that the mother could see Jack, say that the mother might see Jack initially with someone else present, because Jack might be a bit, feel a bit strange seeing his mother having told on her for hitting him. The English courts can require the mother to give up her passport whilst Jack is with her and take those sorts of precautions. They can say that she cannot leave England in any way, or maybe not even leave a section of London whilst she has him. That's pursuant to the 1996 convention that they get that sort of urgent subsidiary jurisdiction. The next thing that happens to Jack. Okay, Jack's father's successful in establishing that there's a grave risk of harm arising from the mother's abusive behaviour 11 months after the proceedings were initiated, and the court exercises its discretion to refuse return, and Jack gets to stay in London. Jack's mother applies for custody in Australia. Now, she still can actually do that under the 1996 Convention because there's another 12-month time limit in relation to those matters to keep jurisdiction alive. There is provision for, at that point, Australia to say, look, the mother's here, but Jack and the father are over in England, whereas Australia has primary jurisdiction. It makes more sense for the English court to determine what sort of time there should be, because Jack's there and can be interviewed by a social scientist in England. So Australia can transfer Australia's jurisdiction to London or to England and give the English courts jurisdiction. By the same token, the English courts, if Jack's father or someone made an application in England, could request a transfer of jurisdiction from Australia. Now, if this sounds a bit complicated to you in the terms of Jack's family, can I tell you it would be much worse if you were sitting here listening to me go through the articles one by one. So this is probably the easiest way of doing it. So Jack stays in England with his father. 4 years later, Jack's dad wants to divorce Jack's mum and take Jack to go and live in Morocco. Dad anticipates that the mother won't agree to relocate Jack and that the father will have to make an application to a court. The Protection Convention formula for determining jurisdiction provides Article 5. The divorce and the relocation would be properly heard, or the English courts have jurisdiction to hear that because Jack's habitually resident there. If Jack and his father had found their way to Morocco, and there was going to be a divorce, there would be a possibility of a subsidiary jurisdiction being exercised under the 1996 Convention because it's part of a divorce application. But absolutely, obviously, Australia, where the mother lives, has no jurisdiction at all under the 1996 Convention. Jack's parents can't agree about relocation, and unbeknownst to Dad, Jack's mum enters England and she snatches Jack back from England and takes him back to Australia. The father's worried that the mother will start hitting Jack again, and even before he makes an application for return under the 1980 Convention, he makes an urgent application in Australia under Article 11 to protect Jack, and orders are made that the mother won't do certain things and that she'll undergo counselling and matters of that nature. These are made under the subordinate jurisdiction that Australia would have because Jack is there, even though he's there wrongfully. Mum and Dad go to mediation with Reunite International. They agree that Jack can go back to Dad and live in London, but they don't agree that then Dad and Jack can go to Morocco. There are, however, proceedings. There can be proceedings, obviously, in the United Kingdom. And when there are, and Jack's father is successful in getting orders that he can go and live in Morocco, Jack wasn't represented in those. Jack's interests weren't separately represented in those proceedings. Anyway, Jack goes with his dad to live in Morocco. 2 years after Jack and Dad have been in Morocco, they move to Argentina to live with Dad's boyfriend, called Greg. A year later, Dad and Greg marry in Argentina because that's a jurisdiction that has same-sex marriage. Mum likes Greg and likes him so much that she thinks that Greg should share parental responsibility for Jack with her and the father. So the three of them have shared parental responsibility. A short time later, Dad, Jack and Greg moved to Morocco to live permanently. Now, Morocco is a 1996 convention country, but it's not a convention country that actually accepts same-sex marriage or accepts the basis upon which Greg got to share parental responsibility. So the 1996 convention provides that Greg will retain parental responsibility that he got in a jurisdiction that did recognise he could have it. But for all the time he's in Morocco, he won't be able to exercise it. So he doesn't lose it, he just doesn't get to exercise it. Mum wants to have access to Jack in Australia pursuant to the last access orders made in London. She seeks recognition and registration of the orders made, the English orders in Morocco. Dad objects to the registration of the access order on the basis that Jack hadn't been represented in the proceedings in which that order was made, and the order is not enforceable for that reason. Jack's now 17 years old and living with Dad and Greg in Morocco. Greg tries to get Jack to join a dangerous cult. Dad goes to the Moroccan police for help, but Greg coerces Jack to go to Uruguay with him. Uruguay is a 1996 Child Protection Convention country. Neither Mum or Dad can request return under the Abduction Convention because it ceased to operate when Jack attained the age of 16 years. So that 1980 convention doesn't help them, but the 1996 convention might. It still applies. The central authority in Morocco can ask the central authority in Uruguay to assist in discovering the whereabouts of Jack. Uruguay has a duty under Article 31 of the 1996 convention to assist Jack's parents to locate Jack. All of this is done through central authorities at no cost, and Jack is located and taken into care. Mum and Dad are told where to locate Jack. Dad arranges for Jack to go to Australia to live with his mother. Dad and Greg reconcile and decide to move to Australia and live permanently. Who has parental responsibility for Jack? Well, under the 1996 convention, everyone's parental responsibility would be revived, and the three of them, Mum, Dad and Greg, would have parental responsibility for Jack until he attains the age of 18. At 18 years of age, unsurprisingly, Jack is absolutely sick and tired of his parents and he leaves home, and that's the end of the story. But effectively, that's how the 1996 convention could operate to protect Jack. Thank you for your patience. Thank you for listening to me. If you get the PowerPoint, there's an enormous number of slides behind it that tell you all about, in detail, the 1996 convention, but it's simply too dry for a presentation such as this. So thank you.
Thank you, Justice Bennett. Thank you for a very comprehensive introduction, and also thank you for your chocolate. Did you all get a bite of the chocolate? It's very yummy. I hope I don't have any chocolate sticking on my teeth. All right, let's move on to the original perspective. Let's firstly invite Honorable Justice Amy C. Lazaro Javier to the podium. Welcome.
Thank you. Okay, where's the clicker? Can you move this a little so I can also? Yes.
I gotta be careful.
Yeah, thank you. Okay. This is what I should click. This one. Which? This one. Okay. Okay. Can I add one? Ah, yes. Okay. Thank you very much, Emilia. You know, I agree with you on two things. First, air conditioning supply in this part of the world is always abundant. And second, yes, I agree with my good friend, Supreme Court Administrator Raul Villanueva, that your hosting has been impeccable. And may I add also that your fashion sense is also flawless. Thank you. She's the peg of a perfect MC. Everyone here is worth mentioning because everyone here is important. But due to time constraint, I can only mention a few of them, at least for now. Dr. Geraldine Go Escolar, an embodiment of woman empowerment. Honorable Justice Victoria Bennett, the original icon of brains and beauty. It's so difficult to speak of children and the Hague Convention on the Protection of the Child without mentioning the name of Justice Bennett. This is for you, Justice Bennett. Thank you for protecting tirelessly the children of the world. My fellow panelists, Mr. Stephen Yao, and where is Miss Yet Ngofu? Hello? Yes, there you are. And the other panelists here present who spoke before us and who will speak after us, the able and efficient organizers of the HCCH Asia Pacific Week 2023, our gracious and generous hosts, the Hong Kong Special Administrative Region of the People's Republic of China, its highly revered officials and leaders, the University of Hong Kong, and of course, my beloved friends and colleagues from the Philippines, the most represented in this forum. The awesome court administrator, Raul Villanueva. I'm returning the favor. Justice Angeline Kim Posale, yes. Director Diane Miranda Pastrana, Professor Elizabeth Pangalangan, the biggest delegation in attendance, the brilliant lawyers and staff from the Philippine Supreme Court, he's not here, but I would like to mention his name because he has been religiously present for 3 days already. Our Vice Consul, Alan Rebote, our future leaders and shapers of the world here present from the Philippines, Hong Kong, the People's Republic of China, and our other esteemed neighbors in Asia and the Pacific, especially those students and others who have been graciously assisting us since day one. The hospitable people have taken good care of us like their own, making our stay in one of our favorite destinations in the world truly remarkable and comfortable. Thank you from the bottom of our hearts. This is for you. Gentlewomen and gentlemen here present, our fellow advocates for the protection of children, good day, everyone. Thank you for inviting the Philippines, this is for HCCH, to share our perspective on the key conventions of the HCCH. Now I can click. Okay. I have the honor to present the Philippine perspective on the 1980 Hague Child Abduction Convention, or simply HCCAC. I will focus on the rule on international child abduction cases, which was approved and promulgated by the Supreme Court of the Philippines only last year, October 18, 2022. The Philippines is the 94th signatory to the 1980 HCCAC. Our membership came into force on June 1st, 2016. The HCCAC is primarily based on the principle that it is not in the best interest of the child to be removed from or retained in a place where the child has not attained a degree of integration in a social or family environment. The Philippine government crafted 2 sets of rules for the implementation of the HCCAC, one administrative and another judicial. In relation to the administrative procedure, the Department of Justice of the Philippines, or the DOJ Philippines, as the designated Philippine Central Authority, is tasked to receive all incoming and outgoing applications for the return of the child claimed to have been wrongfully removed from or retained in a country or state of which the child is not a habitual resident. For this purpose, the Department of Justice issued Circular Number 010 dated 22 February 2022, very, very recent. The left behind parent in the Philippines may file the application through the Office of the Chief State Counsel of the Department of Justice, Philippines, which shall transmit the same to its counterpart central authority in the country where the child is found or has been brought. The counterpart country must also be an HCCH party state, which acceded to the Philippines' accession and vice versa. The left behind parent is not limited to the biological or adoptive parent. It also covers another person or an institution exercising rights of custody or access over the child. Section 7 prescribes the procedure after the filing of the application. It is flashed on the screen and will also be posted later on. The first act of the day is to locate the child. Is the child really in the country? The grounds for refusal of the application. Okay. All right. The grounds for refusal of the application are flashed also on the screen. One is when the child objects to being returned or has attained an age and degree of maturity at which it is appropriate to take into account the child's views. These grounds again will be posted later. Notably, in one case, the Supreme Court of the Philippines awarded the custody of a 5-year-old child to her grandparents instead of her biological parents. For she manifested that she would kill herself or run away from home if she were forced to live with her biological parents, who, according to her, were physically and psychologically cruel to her. For the court, the best interest of the child can override procedural rules. Okay. The administrative proceedings, okay, I will go back. This one? Yes. Okay. Thank you. Administrative proceedings before the DOJ Philippines. The HCCH unit shall request through its counterpart central authority to get the parties to agree on the possible voluntary return of the child. Should this effort succeed, the immediate return of the child shall be effected through coordination between the central authorities. If number one fails, it's not much. Okay, if number one fails or cannot be done, the left behind parent may file a case before the appropriate court. Okay. I should now be on. Okay. Can the left behind parent go directly to the courts? Yes. Under Section 9 of the DOJ Circular Number 010. You know, the Philippines also prescribes administrative procedure because it is inexpensive and it is more expeditious for the parties. So when the filing of the petition is done in court, the petition may be filed with a family court, or if there is no family court in the area where the child is located, or if the child's location is unknown, the petition shall be filed with the regional trial court applying the regular rules on venue. Petition, a verified petition is required, and these are the contents of the verified petition. They are flashed on the screen and will be uploaded later. Also, the petitioner may seek provisional remedies that are flashed on the screen and will be uploaded later. One is an order for temporary rights or access and supervised visitation or contract arrangements with the child, contact arrangement. So the court shall require the respondent or the taking parent to file a comment within 5 calendar days from service of summons. Please take note of the very short timeline because where the child is concerned, time is of the essence. So what happened if the comment is not filed? The family court shall render judgment as may be warranted by the facts alleged in the petition and its supporting affidavits and papers, limited to what is prayed for in the petition. So these are prohibited pleadings and motions flash on the screen. They will be posted later. One is a motion to dismiss. The purpose is to preclude any delay in the proceedings, for again, time is of the essence for the child. The petition shall be heard by the family court in person without prejudice to a video conference hearing if practicable and beneficial for the fair, speedy, and efficient administration of justice and in accordance with the Supreme Court approved guidelines. Okay, this is very important. The preliminary conference. The court, among others, shall initiate an amicable settlement between the parties. If the effort of the court succeeds and the voluntary return of the child is agreed upon, the parties shall be required to execute their compromise agreement on the basis of which the court shall render judgment. Because of the importance of the preliminary conference, the non-appearance by either party carries certain consequences. If the petitioner or his or her authorized representative and counsel fail to appear, the petition shall be dismissed. If it is the respondent or his or her authorized representative and counsel who fail to appear, the judgment shall be rendered as may be warranted by the facts alleged in the petition and its attachments and limited to what is prayed for. So, what happens if the parties fail to reach an amicable settlement? The court shall issue its preliminary conference order and may deem the case submitted for judgment based on the pleadings, other attachments, stipulations, or admissions, even without position papers. Okay, 5 days from termination of the preliminary conference, the parties shall be required to submit their respective papers, position papers. That is, if no judgment on the pleadings may be rendered by the court because it is not proper based on the record. Okay. Note again that time is of the essence. We always want to stress that. Hence, if judgment based on the pleadings is proper, the same shall be rendered when? Within 15 days from issuance of the order. Okay, custody rights. You know, the family court shall not decide on the issue involving custody rights in a petition for the return of a child because custody rights are not covered by the HCCH. Okay, the petition for the return of the child may be denied, okay, on grounds that will be posted later. Essentially similar to the grounds where the return of the child is also refused, okay, in an administrative proceeding. Okay, now, if judgment is rendered, it is immediately final and executory unless restrained by the appellate court and only reviewable through a petition for certiorari under Rule 65. Okay, the timeline mapped out under the rule on HCCH cases is flashed on the screen and will be posted. under the rule, the court aims for the quick resolution of cases involving international abduction of children. To repeat, time is of the essence, and it would be in the best interest of the child that the case be quickly resolved and the child immediately restored to his or her country of habitual residence. Now, what happens if there is a pending custody case? That pending custody case between the parties will be suspended, okay, until the petition filed under this rule is resolved with finality. Now, what if in the meantime another court renders a judgment in the custody proceedings? That decision will be considered or may be considered by the court having jurisdiction over the petition for the return of the child. Okay. During our recent meeting in Singapore, the members of the working group of the CACJ on cross-border disputes involving children, which I chaired together with Justice Debbie Ong of Singapore, we discussed family mediation, and we all agreed that it is the best alternative mode of resolving cross-border disputes involving children. Okay. It is also good to learn that at least two of our members in the ASEAN have already a family mediation procedure in their system in place. It's Singapore, and the other one is Thailand. Okay, the others, like the Philippines, we're just starting to formulate our own family mediation rules. Okay, and then another initiative is the provision of resource space for mediation. We agreed on that so that we can have ready access to the mediation proceedings if already existing, okay, in the neighboring countries, our brothers and sisters in the ASEAN. And then we can verify court orders also. Verification of court orders, this is so easy, this can be so fast, expeditious, if everyone in the ASEAN and everyone perhaps in the world is a member of the Apostille Convention. But the problem is only 3 of us are members of the Apostille Convention. So we have to come up with a proposed flexible rules on the verification of court orders. In the Philippines, there are cases where involving fake court orders in adoption or in annulment of cases, and we want to avoid that, especially if there is the element of interaction with another country. Okay, but we're into that, and we are convincing our other ASEAN neighbors to convince their respective states to also adhere to the Apostille Convention. Okay, so there's the resource space for mediation. Okay, and these are the future actions of the Philippines on family mediation, and we would like to learn from the best practices of Thailand and Singapore, the only 2 members of the ASEAN which already have their respective family mediation procedures in place. We are also eager to learn from the best practices of Australia in protecting the best interests of the children and their proceedings on family mediation. I talk about this with Justice Bennett, and Justice Bennett is just so gracious to say that, yes, she will help us and she will accommodate us. Now, The Philippines is now currently drafting the model rule on video conferencing, and this might also apply to HCAC cases being cross-border disputes. We also wish to share that what we humbly consider as a trailblazing blueprint of action for judicial reforms of the Supreme Court of the Philippines, called the 5-Year Strategic Plan and Judicial Innovations for 2021 to 2027. It envisions a more efficient, innovative, and accessible justice system for the people, especially and including the children. In the implementation of the SPJI, we are guided by these 4 principles: justice that is timely and fair, justice that is transparent and accountable, justice that is equal and inclusive, and justice that is technology adaptive. By 2027, this might sound ambitious, but it's doable. The Supreme Court of the Philippines aims to have achieved a 100% paperless judiciary. And I don't know if the present court administrator will still be with the Supreme Court as court administrator or as member of the Supreme Court itself. Which one would you like? We shall be distributing copies of the SPJI handbook and posting the link to the Supreme Court website for the SPJI. We hope you also find it as a worthy source of inspiration. So in closing, yes? Well, not yet. I'm not thanking you yet. Okay, anyway, this is the wrong, but it's okay. In closing, let me share with you the following pronouncements of the Philippine Supreme Court on the duty of the state to protect children. That's not the one. Okay. Children may constitute only a small part of the population, but the future of this nation hugely, if not entirely, depends on them. And the court will not in any way waver in its sworn duty to ensure that anyone who endangers and poses a threat to that future cannot do so with untouchable impunity, but will certainly be held accountable under the law, per Chief Justice Jesmundo. And another one, what truly makes us human is that we care, nurture, and protect our children, because we hope that they can make their world better than ours. Per Senior Associate Justice Leon, and please report to him that I quoted him. Okay. It is said that children are the world's most important resource and the best proof that God has not given up on humanity. The worst crime humanity can do is to abandon the children. Let us not make this mistake. Let us not abandon the children. If we do, we abandon all hope. Thank you, HCCH. Thank you, Hong Kong. Thanks, everyone. Hasta la vista, mabuhay, session.
Thank you. Bravo. Bravo. Thank you so much, Justice Lazaro. Thank you so much for your incredibly kind words. And you look stunning yourself indeed. Thank you. I love our friends from Philippines. Thank you so much. Well, ladies and gentlemen, let's move on to explore more on the regional perspectives. Now let's welcome Mr. Stephen Yao to the podium.
Good afternoon. Because of the time factor, I'm going to cut short my presentation. I guess probably you're quite tired though. My presentation today is about my work, that is my organization work in the support of the 1980 and the 1996 Hague Convention. That is the presentation outlined about ISS and the two convention and the ISS mission moving forward. International Social Service is international non-government organization which was founded in 1924. Next year is our 100 years anniversary. ISS is now a network of more than 120 national entities across the globe with focus on the cross-border social work and related work. And ISS Hong Kong is the largest member of the ISS network from the operational point of view, and celebrating its 65 anniversary this year. And our work in support of the 1980 Hague Convention. ISS is a global network that conducts inter-country child protection casework services, including those related to the 1980 and 1996 Hague Convention. We provide specialized inter-country child protection casework service internationally, and many of them provide international parental child abduction, legal and social work service. And we can be of evident help internationally if expert assistance is required by state and central authority across border child protection casework service. And we also work, with the child protection authorities around the world to assist with the care and protection of children. We are a competent international authority in international child protection and family reunification matters, while recognizing the legal requirement of the 1980 Convention. ISS also focus on social work orientated and the child-centric approach, which prioritize the safety, well-being, and the permanency of a child in need of care. The ISS network will work with children beyond court orders to ensure the child is safe and settled over the longer term. It is important to recognize the critical importance of international family mediation is an alternative option and complementary measure to the 1980 Hague Convention proceeding in some instance. ISS specific expertise in supporting children and family involved in cross-border dispute through the use of expert-trained family mediator and social worker. And we conduct international family mediation in several member countries. For our social workers, the ISS Hong Kong experience in the abduction cases, we provide counseling service, emotional support, and conduct social investigation. And as per request by family courts in Hong Kong and overseas country. And our social worker will try to mediate with both parents, brief the other party on the development of their children. Say, for example, pass the child's photo to other parents to bring toys, clothing, and gift to the child. And we link with the mainland resources, mainland China resources. We have office in Shenzhen and Guangzhou, and also we liaise with the local women federation and social workers for assistance. There's a Women Federation all over China. And I just want to share with you one case, child abduction case involved Hong Kong and Germany. The father, Jacob, is a German national, a pilot based in Frankfurt, frequently worked between Hong Kong and Frankfurt, and met Marianne when she studied a master's degree in Frankfurt. The woman, a Hong Kong citizen, married Jacob in Germany, and request by Jacob to live together in Frankfurt. And the son Tom was born in Frankfurt, a German national, and also at the same time Hong Kong citizen, studying in primary school in Frankfurt. And Jacob planned to move to New York as requested by the employer. He did not need to fly to Hong Kong as frequent as before. He expected Marianne and Tom could move to New York with him. Marianne expressed she did not like the American lifestyle. She also expected Tom to receive education in Germany as usual. She did not oppose Jacob to stay in New York when there was a trip. And Jacob and Marianne had a few serious arguments about the relocation. And Marianne visited her family in Hong Kong with Tom few weeks in the summer to calm down. And in September, Marianne told Jacob that she did not plan to return to Frankfurt. At the same time, she was making an application for divorce in Hong Kong and applied for the sole custody. And Jacob applied for a 1980 HCCH case at family court in Germany. And the German court contacted the mediation institution in Berlin to seek calls for the family mediation between Jacob and Marianne. The mediation was held online in Frankfurt, in Hong Kong. Two mediators, a German lawyer and a Cantonese social worker, that is ISS Hong Kong social worker. She is also a qualified family mediator, were allocated for the mediation. Mediation was scheduled for 3 consecutive days. And Tom stayed with Marianne in Hong Kong and remained in telephone contact with Jacob. He also met with Jacob regularly. The couple relationship improved and were able to work together for co-parenting. That is the work of our organization. I also, we have a guide to international family mediation, and also the Charter for Family, the International Family Mediation Process. For the 1996 Child Protection Convention, we can widely claim that we are appropriate other body to cooperate with the central authority. I don't read this sentence now, okay? The ISS is principally a global social work network whose mission is to protect, defend, and support the best interests and rights of children and family impacted by cross-border issues. ISS focus on the need to improve the protection of children and international situation. And one of the ISS core service is facilitating and conducting effective international kinship care practice. This includes assessment report with statutory checks, transitions plans, and post-placement report. May also include specialized legal and immigration advice to ensure the child's able to safely travel and legally remain in their prospective new country. And ISS is strongly convinced the 1996 Child Protection Convention potential as the most important international instrument on cross-border child protection. However, the current application of this convention is limited due to its ratification by only 54 countries, whereas the 1980 Child Abduction Convention is ratified by 103 countries, and the 1993 Adoption Convention is ratified by 105 countries. And you see, the cross-border cooperation for social investigation in ISS is the social investigation in China, Hong Kong, and Macau is done by ISS Hong Kong social worker. The social investigation in country out of China, Hong Kong, and Macau is we refer to ISS members or member for the follow-up work. The common assessment framework in ISS, this is our framework. And also I would like to share with one case, kinship placement case, Australia and China. Three children were born in Australia. Their parents were a Chinese migrant couple. The parents are serving sentence in prisons due to the conviction of drug trafficking. The children can only be looked after by the parents' friend. And ISS Hong Kong received the case referral from ISS Australia and helped to locate and visit the grandparents in China. It helps the authority in Australia to come up with the responsible and effective decision regarding the children's care arrangement. The children returned to China, and the ISS Hong Kong assists in the escort and also the post-placement interviews afterwards. And no, I'm not going to, what happened to the sound? Okay, the convention. I just want to share with my regional observation and thought. The 11 countries or regions signed the 1980 Hague Convention, and only 2 countries in the region signed the 1996. And for a harmonized implementation of this 1980 and the 1996 Hague Convention, Asia and Pacific countries that have not yet joined this convention should be encouraged to do so to further consolidate cross-border cooperation and recognition and enforcement of order. While there is recognition of the need of the international cooperation in child adoption cases, the specific approach and level of implementation varies across Asian countries based on individual circumstances. The participation of NGOs and national authority working together can mitigate the variation. Capacity building, training, and the professional development for field practitioners such as lawyers, social workers, psychologists, etc. in Asia Pacific region is crucial to enhance their awareness towards the convention. And of course, our priority is to protect the best interest of the child. We'll continue to contribute to the advocacy effort for wider ratification of the 1980 and the 1996 Convention. And also we continue to provide practical cross-border casework service and in consultation and parallel with the legal aspect handled through these two central authorities. 1918 and 1996 Central Authority, we will continue to provide practical cross-border casework service for non-contracting states of 1980 and 1996. In countries ratifying the convention where there is not a strong social service workforce, ISS member could be cross-border casework facilitator and a service provider, and will continue to protect the children across border in emergency situation in the shortest possible time by engaging diverse multidisciplinary stakeholder and developing good practice for cross-border mediation, and will provide cross-border casework training to new 1980 and the 1996 Child Protection Convention Central Authority and the local social service workforce. Developing a dedicated resource center on cross-border child protection, replicating the very successful model of the International Reference Center for the Rights of Children Deprived of their family. That is the program run by our ISS General Secretaries in Geneva. So we hope we're able to develop a dedicated resource center. And okay, 400 years at the international level and over 65 years as ISS Hong Kong, we have been relentlessly, providing cross-border casework service in child protection and family reunification in fast-moving and often complicated working situation. We are ISS Network are proud to be associated with the Hague Convention and its permanent bureau, as well as a regional representation in Hong Kong. ISS specialists from the Geneva headquarters and everywhere will be representing the ISS network in the Hague Special Commission meeting in next October. Thank you. That's my presentation.
Thank you. Thank you very much, Mr. Yao. Please join our panelists. Thank you. And now, ladies and gentlemen, lastly, we will hear from Ms. Fu on the topic of regional perspectives. Please join me on the podium. Thank you very much.
I think it's good afternoon, and I'm very conscious of what has been said by Stephen, that I'm the last speaker and everybody is tired. So I shall try and deliver a quick snapshot of the position in Malaysia. I may try and rush through my points, but I just would like first to thank the HCCH for inviting me to speak from a non-convention country. We are not a party to the Hague Convention on Child Abduction. But the crux of my presentation is really on the desire for us to accede to it and the impediments that have made it difficult for us to do so. Now, to begin with, Malaysia is not a party to the Child Abduction Convention, nor is it a party to the Child Protection Convention. However, we had acceded to the United Nations Convention on the Rights of the Child since 1995 albeit with reservations, and 2 of those reservations pertain to the child's religion. That's where our problem lies. Now, but there are obligations in the UNCRC which imposes on Malaysia obligations to deal with wrongful removal of children. Article 9, for instance, states that state parties should ensure a child is not separated from his or her parents against their will. Article 10 says the right of a child to maintain a regular personal relationship and direct contact with both parents. Article 11 states that state parties shall take measures to combat illicit transfer and non-return of children abroad. And Article 35 says that state parties should take all appropriate measures to prevent the abduction of, sale of, or traffic in children for all purposes. So we do have obligations that we have actually signed on to under the United Nations CRC. Now, I cannot move on away from this topic without bringing the spotlight on one case, the case of Jacqueline Gillespie and Raja Bahrain. A lot of you are very young, so I'm not sure whether you would have been around when this made the headlines. This was in 1992, an infamous abduction of 2 children, a daughter 7 years old and a son 9 years old, from the Australian mother by their father, a Malaysian prince, during an access visit. Now, according to what was reported, the father took the children by boat from Queensland via Sulawesi to Terengganu, Malaysia. Now, the case sparked a diplomatic row between our Malaysian government, Mahathir at the time, Mahathir Mohamad was our prime minister at the time, and Paul Keating of the Australian government, because the father had indicated at a news conference he was never returning the children. And unfortunately, Australia does not have an extradition treaty with Malaysia. Now, those children remained in Malaysia and were only reunited with their mother after 14 years in April 2006, when they traveled to Australia in their adulthood. Now, much controversy surrounds that saga, the prince claiming that the mother did not bring them up as Muslims in accordance with a settlement agreement he had entered into with her. But that case, unfortunately, puts Malaysia in a terrible light because it has cast a long shadow that Malaysia is a safe haven for abductions. So we have problems in that we are not a signatory, because Malaysia is not seen as a safe jurisdiction to bring a child there, there being no guarantee that the Malaysian government or the courts will return the children to the child's country of habitual residence. And correspondingly, we suffer too, because there's no guarantee that a Malaysian child taken abroad, abducted abroad, will be returned to Malaysia, since we are not a party to the Hague Convention. What is the background behind this impediment to us being a party, being a signatory to the Hague Convention on Child Abduction? Now, it has to do with the dual system of laws we have in Malaysia. Article 3 of our federal constitution states that Islam is the religion of the Federation, but other religions may be practiced in peace and harmony in any part of the Federation. Malaysia has a dual system in relation to family law, and they both run parallel. Civil family law for non-Muslims and Sharia law for Muslims. Now, each system is distinct and separate from the other, separate courts, no right of encroachment into the matters in the jurisdiction of each of them by the other. That is a specific provision in our federal constitution. Now, documents that we have all studied have shown that Malaysia's hesitation to accede to the Hague Convention emanates from this fact that a huge part of Malaysia's population practices Sharia law. In fact, 63% of the population are Muslims. Now, from the Sharia law perspective, compliance with Sharia law remains paramount, even in child abduction cases. From the Sharia law perspective, along with welfare and best interests of an abducted child, the religion of the child, which is Islam, must be part and parcel of that afforded protection when deciding the return of an abducted child. Now that's a problem. I mean, I just want to quickly say that in fact there was a protocol, an attempt at a protocol to be drawn up by Switzerland sometime in 2008. And when that protocol was presented to the Malaysian Attorney General's chambers, this was the first comment to Article 1, and that is, generally, in the event of a child being removed or retained unlawfully, the child should be returned to the jurisdiction from which he or she was removed. Nevertheless, if in doing so, it defeats the purpose of protecting the welfare and interests of the child, the protection and welfare of the child should prevail, and the religion of the child should be part and parcel of it. So that's the indication of our the position taken by the Malaysian Attorney General. So to one article in that protocol, that there be no reservations to the protocol, it was also stated by the chambers that there seems nowhere in the draft protocol that guarantees protection of religion of the child, especially in cases where one of the parents renounces Islam. That's always been the problem. Thus, reservation must be allowed in the draft protocol as a move to provide leeway for the Muslim parties in order to ensure that the religion of the child, Islam, is protected alongside the welfare of such child. So I'm not going to, sorry, I didn't show you that. Now, like all Sharia law systems, Malaysia appears to be looking to see if a reservation clause may be expanded to allow for reservations in relation to religion. Now, I think that would go against the main thrust of the convention, because the issue of religion is a factor in the merits of custody, not of the abduction. So we have a problem. But Malaysia's dual system of law means that the non-Muslim civil family law coexists and runs parallel with the Sharia law. So for the non-Muslims, the dual concerns of international parental child abduction remains at large. The incoming abduction of children from abroad to Malaysia, the outgoing abduction from Malaysia to a foreign country. I just mentioned two cases. There was one where I think the Child State Authority versus Ayub, this is a 1997 case, where the abduction of a child by a Malaysian mother from Arkansas to Malaysia, and where of course, without the consent of the father, the child resided in Malaysia for a few years. Then the mother applied to take the child to Australia. Father agreed to that. And then when the child was, because he believed that once the child goes into Australia, he would be able to secure the return of the child. And he did just that. But the Australian court grappled with the fact that the child was not abducted from Arkansas straight to Australia. It went through Malaysia. And there was some issue of the child having been settled in Malaysia. And whether the father, by agreeing to let the mother take the child to Australia, he had acquiesced to that move. Anyway, the Australian court ruled in favor of the return of the child to Arkansas. Then there was, of course, the other case of Lu and Kaliao, where the Australian court refused the mother's request for the child to be taken back to Malaysia for a holiday. She's a Malaysian mother. Just to meet with her Malaysian family. She was prepared to secure, I think, 20,000 Australian dollars as security, to place 20,000 as security. No, the Australian court did not allow the child to be taken to Malaysia. So just quickly, Malaysian common law, in the civil family law, our family law is rooted, the jurisdiction is rooted in the common law system, fundamentally. And in matrimonial matters, the Malaysian Matrimonial Act says that we should give relief in conformity with principles of the High Court of Justice in England in relation to custody. Two, we we are guided by, or English cases are of persuasive authority unless there are provisions made by our statute law. Now, so the common law principle applies, and what I think most jurisdictions who have practiced common law are bound by these principles of common law, namely that foreign custody orders are not final and conclusive. They are always open to revision. The best interest of the child remains the paramount consideration to which even the foreign custody order from a court of competent jurisdiction must yield. So the non-finality of a foreign custody order gives rise to forum shopping. The federal court in Malaysia holding that the Malaysian court is entitled to rehear the matter, form an independent judgment on the issue of custody. Otherwise, it would be a negation of the welfare of the child being the paramount consideration. So what has happened is that since we do not have the benefit of any statute or the convention, our Malaysian civil courts have attempted to address this issue of child abduction via the common law way of dealing with it case by case. So let me start with, I just want to give some assurance to people who have had children abducted or who have cases in that regard when children are taken to Malaysia. So we have first this case of Nadu Chalayan. That's a long name against Nadu Chalayan, Balasubramaniam and Kohela. Now this case concerned two children, Canadian citizens born in Canada, the father a Canadian national, the mother a Malaysian citizen, but who had applied for and was granted permanent residence in Canada. The family came to Malaysia for a holiday when the mother initiated Malaysian custody and divorce proceedings in Malaysian court. Divorce was struck out on the basis that there was no jurisdiction for her the court to entertain her divorce. But the court granted custody of the two Canadian children to their Malaysian mother. Note, they were only there on holiday. But on appeal, the Court of Appeal reversed that. The Court of Appeal accepted jurisdiction over the children as they were physically in the country, but the court held that a distinction needs to be made in relation to the terms of, So a distinction needs to be made in terms of the duration of protection a court should afford to children who are long-term residents in Malaysia, children of Malaysian citizens or the children of Malaysian permanent residents, and transient visitors to Malaysia, children of foreign nationals, a distinction to be drawn between the two. So the court held that where there are these children are children of transient visitors, protection should only be accorded to them as long as the children can lawfully remain in the country. The court will only intervene if the harm to the children can be classified as a real and immediate danger to their physical well-being from anyone, including the parents, if they were to be returned to their country of origin. So the questions the court considered were where do the children belong? Where is the matrimonial establishment? And which is the proper court to decide the future of these Canadian nationals? The Malaysian Court of Appeal held that the children should be sent back to Canada as they were Canadian citizens and had come to this country on a holiday and are hence transient visitors. It was not desirable for the Malaysian courts to make a full inquiry into the wife-husband dispute, especially where the court was satisfied that no obvious harm would come to the children if they were sent back to Canada, the country of origin. The court set aside the order of the High Court, made no concluded view as to who should have custody, ordered the children to be delivered to the father, to be taken back to Canada, for the Canadian court to decide the issue of custody. Of course, the father applied for a stay. The court refused to grant the stay of execution because by then the children had already been in Malaysia for 7 months. There was a second civil case that developed in 2006. Just quickly, I will run through it. The parties were all Australian citizens. The husband left Australia with the daughter ostensibly for a holiday in the United Kingdom and Europe and was supposed to return to Australia, but he entered Malaysia. He applied for, and then he kept his whereabouts unknown and hidden from the wife. When the husband did not return the daughter, the wife applied to the Australian courts for interim orders for custody to her and the return of the child. The husband was aware of and had notice of the Australian proceedings. In fact, he even participated in the Australian proceedings. The husband subsequently applied for and was issued a social visit pass by the Malaysian immigration authorities under this Malaysia, My Second Home program. So he had a right to reside in Malaysia. Despite the husband's submission and participation in the Australian proceedings, he filed proceedings in Malaysia. And without disclosing the Australian proceedings, he proceeded to and obtained a Malaysian ex parte interim custody order and guardianship of the children, of the daughter, sorry. The wife then applied in Malaysia to set aside the Malaysian court order. So what did the Malaysian High Court do? It considered the case on the principles of forum non-convenience, held that Australia was the forum with the most real and substantial connection, and that consideration should be given to the, with the most real and substantial connection, and decided that the Australian court would be the more appropriate or natural forum to hear and decide the matter. So on those facts, of course, in that case, the father had also submitted to the Australian courts in his filing of affidavits. And they held that he should be stopped from taking a second bite at the cherry. Nevertheless, following Neduchalayan, the earlier case, the court said that it should set itself against unilateral removal of children to Malaysia, and unless there are compelling reasons to the contrary, that the child will be harmed if returned to Australia, this child ought to be sent back, and she was. She was sent back with the Australian mother. So in summary, we say that the Malaysian judiciary has attempted to deal with child abduction cases on a case-by-case basis. These are just the main principles, and I've already gone through it, but quickly. The Malaysian court has jurisdiction over any child physically within its jurisdiction, regardless of whether it is a citizen or not. In all matters relating to children, the welfare and best interests of the child remains the paramount consideration. An order of a foreign court is not final and conclusive. Malaysian court is entitled to enter into the merits afresh. However, where all parties are foreign nationals and only transient visitors to Malaysia, the Malaysian court will exercise its discretion to return the child. If the court is satisfied, no obvious, real, or immediate harm would come to the child if returned. without a full inquiry into this dispute. And so so the court will apply the forum non-convenience principle, and if you file it on a certificate of urgency with exchange of affidavits and submissions, it could take sort of about a year for you to get the child returned. Not ideal, but at least the Malaysian courts are trying to deal with it as expeditiously as it can. So, at the end of the day, I still conclude it'd be more desirable if we become a party to the Hague Child Abduction Convention. But all I can say is that the present case law in Malaysia is a step in the right direction. Now, so Malaysia remains at a disadvantage, as I said earlier, when a Malaysian child is wrongfully removed and retained abroad. We have no mechanism to secure that child's return promptly. And when a Malaysian parent is married to a foreign spouse, married to a foreign spouse in another country, applies to bring a child to Malaysia even for a holiday. Malaysia, not being a signatory to the Hague Child Abduction Convention, is oftentimes used as a basis to either deny the application or impose restrictive conditions. So as I set out to say, Malaysian practitioners in the civil jurisdiction are still hopeful that the impediments will be resolved and Malaysia will embrace the Hague Convention on Child Abduction. Can the HCCH work hard in that direction? Thank you very much.
Thank you. Thank you for addressing. Thank you, Ms. Fu. And thank every and each one of our amazing panelists. Let's give it up to our panel. Thank you for a wonderful job. And I'm so sorry, we're afraid that we don't have time for the Q&A session. So thank you again. Thank you very much. Thank you. Please. Thank you very much. And also, we have to skip the coffee break. So as we move on to the final session for the day, please just feel free to grab a coffee or some snacks. As we're moving on to the last session, focusing on the 2000 Protection of Adults Convention and the 2007 Child Support Convention. For this session, we are delighted to invite 3 speakers to the stage. All right, so let's please welcome the Honorable Chief Justice John Pascoe, ACCVO, former Chief Justice of the Family Court of Australia and former Deputy Chancellor of the University of New South Wales, and Honorable Angeline Mary W. Kimbo-Sil, Associate Justice of the Court of Appeals of the Philippines, and Mr. Enzu Chow, barrister from the Hong Kong SAR of the People's Republic of China. Welcome to stage. Welcome to have a sit on the stage. All right, so without further ado, I'd like to invite the Honorable Chief Justice John Pascoe, ACCVO, to deliver the introductory presentation. Welcome to the podium.
Are we on? Start. Victoria, start. Yes. That was a very quick changeover. Thank you, Madam Chair, distinguished guests, colleagues, and new and old friends. It's a great pleasure to be here in Hong Kong to participate in this very important conference, which demonstrates the importance of private international law and the Hague Conference within the framework of increasing global mobility, an ageing population, more transnational families, and a real need for institutions which promote and protect human rights and the rule of law. Both conventions that we are talking about today are important in a human rights context. I wish to thank Mr. Philip Lawtee for his very informative presentation, the 2000 Protection of Adults Convention, on the 11th of October 2021, which I have drawn on for this presentation. As many of you know, the Permanent Bureau is a great source of information and resources, and I commend their website to you. I also want to thank Justice Bennett for her assistance to me, and I should say that when I was the Chief Justice of the Family Court, I was very much in awe of the work Justice Bennett did as the network judge and to support the Hague Convention. And the benefit of that work to Australia was recognised when Justice Bennett was appointed an officer in the Order of Australia. So she is a very hard act to follow. The 2000 convention was concluded by the Hague Conference in 2000 and entered into force in 2009. It follows the general structure of the 1996 Child Protection Convention and applies the same solutions on most points. It diverges in relation to jurisdiction. Whilst the 1996 Child Protection Convention is focused on avoiding competition between authorities or courts in different states, the 2000 Adult Convention allows less constraint because whereas it is common for two participants to fight over which country should have jurisdiction to make parenting orders, it's less likely that there will be the same competition for jurisdiction over an adult. So for those reasons, concurrent jurisdiction is allowed, at least for the authorities of the adult's state of nationality. Unfortunately, the 2000 Convention is as difficult to comprehend as the 1996 Convention. Please don't be put off. You don't need to remember when you were dealing with a vulnerable person in a you only need to remember when you were dealing with a vulnerable person in a cross-border situation that the 2000 Convention might assist. The scope of the convention, what it does or does not cover, jurisdiction, applicable law, recognition and enforcement, cooperation, and general provisions. Today's presentation doesn't allow me to go into detail, but I hope you will get a general idea. The Convention provides for each contracting state to designate a central authority. Central authorities are required to cooperate with one another, share information, facilitate communication amongst authorities, discover the whereabouts of an adult, arrange mediations to achieve an agreement, and assist with cross-border placement. Each central authority will, in principle, bear its own costs. Contracting states are Austria, Belgium, the Czech Republic, Estonia, Finland, France, Germany, Greece, Latvia, Monaco, Malta, Portugal, Switzerland, and the United Kingdom. The jurisdictional rule is that only one state's competent authority or court can have jurisdiction at a time on a specific subject matter. This ensures predictability and certainty. The Convention provides uniform rules to determine which authorities are competent to make necessary measures for protection. Choice of jurisdiction should not result in a conflict of jurisdictions, as this would delay the ordering of measures to support care for an incapacitated adult. Article 10 provides for limited jurisdiction in urgent situations. For example, a person on a skiing holiday has an accident and falls into a coma. So he suddenly has no powers of representation. So an authority, a court or guardian institution in the country where the person is hospitalised will have to make decisions and eventually decide the measures and protections to be put in place to facilitate the adult returning to his or her place of habitual residence. Protective measures vary with each legal system. The enumeration given in Article 3 is only illustrative. Nonetheless, it tries to cover a very broad scope, and certain of these elements may overlap, but that makes little difference since the set of rules to which they are all subject is the same. A power of representation may be any number of things. For example, a power of attorney, a living will, or any of the instruments described in Article 15. At the HCCH December 2018 joint conference, it was noted that the cross-border transportability of measures under the 2000 Adults Convention would be providing, for example, information on the future, substantive and formal requirements of such measures, as well as the conditions coming into effect. This is a work in progress. Measures taken in one contracting state are to be recognised by operation of law in other contracting states. That means protective measures made in Germany will be recognised in Portugal without having to go to court. There are grounds for non-recognition which are essentially based on jurisdiction, procedural fairness, and public policy. Recognition is not enforceability. For enforceability, states are required to provide a registration procedure that is simple and rapid. Enforceability may be refused on the same grounds as non-recognition. Generally, authorities apply their own law. Applicable law should have a real and substantive connection. The applicable laws available under the 2000 Convention are presumed to be known to the adult. As a result, they should not be contested by third parties. In exceptional circumstances, an authority may apply the law of another contracting state. It is important for each state to have robust provisions to safeguard misuse of powers of representation in different jurisdictions. This is laid down in domestic law. For instance, a state may have a domestic law to the effect that a person who is employed as a personal carer cannot be named as an attorney or representative, but a spouse or family member can be named. So now let's have a look at feedback from a few countries. Portugal indicates that the 2000 Convention plays a very important role in resolving issues that demand an adequate response in the field of rights of adults who are nationals and live in another country, and which sometimes imply a quick and effective resolution, namely in the field of the administration of assets belonging to people who suffer from a deficiency or insufficient personal capacity. Germany notes that the Convention is a helpful tool which works well within their current framework, but they have indicated that the addition of more states would help to establish routines involved in the operation of the Convention. Now, I am trying to move through all this quickly because I know time is running out. Portugal noted a case where a Portuguese bank initially refused recognition of guardian powers which had been appointed in France in relation to the bank account. Once the central authority appealed to the rules of the Convention, the situation was adequately resolved to the benefit of the Portuguese citizen. Like Germany, the Czech Republic says that the 2000 Convention would benefit from awareness being raised as to its usefulness with professionals and with the wider public. Scotland, although having had few cases at the time of reporting, noted the process in using the 2000 Convention to be straightforward. In Scotland, the Convention implements existing legal frameworks within national legislation, the Adults with Incapacity Scotland Act 2000, which is designed to safeguard the welfare of adults who lack the capacity to make decisions for themselves. Here we can see that in 2016, Hong Kong boasted the longest living population on Earth. We can see that the average lifespan is over 80 years, and that in another 20 years, a third of the population is expected to be aged over 65. Looks quite young to me now. When people retire, they often look to move to other countries, particularly if they have children abroad. It is so important that there is private international law available to assist the elderly, such as the 2000 Convention. Former United Nations Secretary Kofi Annan recognised that we must be a society for all ages when he announced the International Year of Older Persons. The 2006 Convention allows for adults abroad to be treated with respect and dignity where they become temporarily or permanently unable to look after their own interests, and I commend it to you. And again, there are some very helpful resources within the 2000 Convention. And as I said, both of the conventions I'm talking about are very important within a human rights perspective. Socrates, the great philosopher, said, without the wisdom of the elders, there would be no society. So at one end, we need to respect and value our elders. At the other end, our children really are our future, and looking after their rights is also critical. So moving on to the 2007 Child Support Convention. It is a multilateral treaty providing for the robust enforcement of decisions regarding child support and maintenance for families stretched across international borders to safeguard the rights of children and their carers. The objective of the 2007 Convention is to ensure the effective international recovery of child support and other forms of family maintenance by establishing a comprehensive system of cooperation between the authorities of the contracting states, making available applications for the establishment of maintenance decisions, providing for the recognition and enforcement of maintenance decisions, and requiring effective measures for the prompt enforcement of maintenance decisions. Applications are made through the central authority where the applicant resides, noting that residence excludes mere presence. Foundational principle of the Convention is that applicants must have effective access to the procedures necessary to complete their applications in the requested state. The Convention allows for the provision of cost-free legal assistance in certain circumstances, as well as the ability to recover costs from an unsuccessful party in some circumstances. The Convention applies in a variety of situations, including child support matters, recognition of enforcement of spousal support and other maintenance duties which flow from familial relationships, parenting, marriage, or affinity. It applies to all children, regardless of the marital status of the parents. These are the signatories, central authorities of the 2007 Convention. The Convention sets out the processes for central authorities. Central authorities are encouraged to cooperate with each other to find solutions. Central authorities deal with the transmission and receipt of applications and the initiation or facilitation of proceedings in relation to those applications. Each central authority bears its own costs. The bases for recognition and enforcement are broad, and the primary bases are the habitual residence of the respondent or creditor in the state where the proceedings were commenced. In a challenge or appeal of that decision to recognise or not recognise and enforce a decision, a respondent may suggest that the bases for recognition and enforcement as set out in Article 20 have not been met. Those bases for recognition and enforcement and the reference to jurisdiction in that context concern the connections that are required between the parties and the state where the decision maker is located. For example, a court may have the jurisdiction to make a maintenance decision if both parents reside in that state. Therefore, a decision on that basis can be recognised and enforced. Parties are bound in respect of payments falling due between the state of origin and the state addressed for maintenance obligations arising from a parent-child relationship towards a person under the age of 21. These are some of the methods methods Brazil uses for enforcement of maintenance decisions, which include wage withholding, seizure of lottery wins, and incarceration. They do also use more conciliatory methods, such as mediation. Austria does not use imprisonment as a method of enforcement of maintenance decisions, but like Brazil, they use the withholding of wages, seizure of lottery winnings, and the use of conciliatory measures. I will conclude with a case example to demonstrate the operation of the Convention. P and her 2 children reside in country A. P has a decision requiring Q to pay child support and spousal maintenance. The decision was made in country A. Q now lives in country B. P would like the maintenance decision to be sent to country B to have Q contacted and maintenance collected. Both country A and country B are contracting states to the Convention. P will go to the central authority in country A, who will transmit an application with the required documentation on her behalf to the central authority in country B. The application will request that the maintenance decision be recognised and enforced in country B. If the decision meets the requirements for recognition under the Convention, the competent authority in country B will process the request and recognise and enforce the decision. Q will then be advised of the recognition and enforcement and have an opportunity to challenge or appeal the decision to recognise and enforce the maintenance decision. Once the decision has been recognised, it will be enforced in country B by a competent authority. P only has to deal with the central authority in country A. All contact with the central authority in country B will generally take place through the central authority in country A. And here are some helpful resources for child support. So, having attempted to go through quickly, that completes my presentation on the 2000 and 2007 conventions. In closing, I would like to express my thanks to the Government of the People's Republic of China, the Ministry of Justice of the Hong Kong Special Administrative Region, People's Republic of China, and Hong Kong University in supporting a meeting such as this. It provides clear and strong support for international cooperation, human rights, and for the rule of law. For the future, there is much work for the Hague Conference to do over the next 130 years. And in this regard, I note firstly that human rights and private international law are now inextricably intertwined. Secondly, our region is one of the most dynamic and important on Earth. It is very important that the people of ASEAN and the Asia-Pacific region are heard, and the best way to do that is to participate in international organisations, sign up to conventions, make your voice heard at The Hague. And in that regard, if I may be very quick, I was part of an experts group at The Hague, and I kept saying what's being said around this table does not represent the views of many of the countries in the ASEAN area. And I knew that because I'd attended a meeting where the particular issue was discussed. The answer I had back was, well, none of those countries are members here. So there really is a message in that. And finally, having got the signal. I really want to say thank you again to the student volunteers and to the staff of the Permanent Bureau who have worked so hard to make the conference possible. Edwin, I think you were a standout. You have great organisational skills and an ability to herd cats. In a previous life, I was the chief executive of a major food company before, by some strange series of events, I ended up as a judge. Had I still been at the company, Edwin, after this conference, I would have been negotiating an increase in your salary so that you could come and join the company. But it has also been a great thing for me as a former Deputy Chancellor to have the opportunity to be at a university and to see so many brilliant young people at the start of their careers. And at the end of the conference, Edwin, I intend to give you my tie, which is a University of New South Wales tie, the university of which I was the Deputy Chancellor. I hope you will wear it with pride, and I look forward to coming back when you are the Deputy Chancellor of Hong Kong University, but you must not take too long. I'd like to leave everyone with a thought from my Buddhist master, who says that a good life is a life lived bravely in the service of others. May this guide stay with all of you and with the Hague Conference over the next 130 years. Thank you.
Thank you. Let's give it up to Mr. Pascoe. Thank you so much. We enjoyed your presentation so much, and thank you for your generosity. Thank you for your gifts. Well, sharing is caring. Thank you so much, Mr. Pascoe. Let's move on to the regional perspectives. So firstly, let's welcome the Honorable Ms. Kim Po-sil join us to the podium. Welcome.
Thank you very much. Good afternoon to everybody. Ang nom and mabuhay. And this presentation is a perspective from the Philippines, and I'll be touching only on the 2007 Child Support Convention. Okay, the Child Support Convention entered into force in our country on October 1, 2022, and we had 47 countries who acceded to that convention. So for the central authority, which provides for the administrative procedure, it is the Department of Social Welfare and Development, or we call it the DSWD. That is the central authority that handles all the administrative matters. And for the judicial authority, of course, it is the courts. And with the central, my presentation will touch on those two authorities, the central authority and the judicial authority. For the central authority, as stated, the Department of Social Welfare and Development, and it handles incoming and outgoing cases of international child support. It is in partnership with other government agencies and legal agencies to perform its roles and obligations within the convention. And they started only January 2023. So these data started January 2023 to the present. Okay, application of incoming cases is from the central authority of a contracting state to the central authority of the Philippines, incoming. Okay, application for the established enforcement of a decision, the establishment of paternity, and request for specific measures, particularly to locate the person who is obliged to give support. So this is the obligor. The term used in the convention is the debtor, but we use the term obligor, the person who is obliged to give support. So most of the cases to locate the obligor. And second, All these 10 cases were closed. Active cases, they were referred to the other government agencies or other competent authorities. So at least our central authority that started only last January was able to terminate 10 cases as of last 2 weeks ago. Okay, next, for outgoing cases, these are cases coming from our country, the central authority of our country, to the country outside the Philippines, contracting states. Okay, application for establishment of the decision, application for establishment of paternity and decision, request for a specific measure, which is to locate the obligor, and for review and assessment prior to its endorsement to the central authority of other contracting states. So, recipient countries of outgoing cases, United States of America, 19. Australia and New Zealand, 6. Europe, 3. Okay, and 28 cases since January 2023. So case scenarios, what are these cases? For incoming cases, from a contracting state to the central authority in the Philippines. Obligors are persons obliged to give support currently or habitually residing in the Philippines with current maintenance obligation from a foreign court decision, may not afford to provide the required maintenance support on a monthly basis. An example would be the obligor is a Filipino, previously residing in a foreign state with a family. Upon the divorce with the spouse, a child support decision was entered into order. The obligor was ordered to provide monthly support. Upon his return to the Philippines, the obligor returns to the Philippines, he was not able to pay the monthly support and therefore included arrears. So that's one example. That's for the incoming. Now for the outgoing cases, an example would be Filipino children with non-custodial parents habitually residing in a non-contracting state could not access the services of the HCCH child support. So what are the options of the custodial parent to claim financial support due for the child? So this is a question given to the contracting state coming from the Philippines. Scenario 2, Filipino obligee is residing in the Philippines. The obligee is the person entitled to be given support. Okay, the obligor is the person who should give support, is a citizen of contracting state, but habitually residing in a non-contracting state. So how do they deal with that, the contracting state and a non-contracting state? So that is a question before the central authority. Okay, so what has the central authority, what have they done so far? They do partnership building because they cannot operate on their own. So they coordinate with the Immigration, the Bureau of Immigration. They also coordinate with the Department of Foreign Affairs. They also coordinate with the NBI, the National Bureau of Investigation, as well as the police, particularly in cases to locate where the obligor is. Okay, and second, for streamlining and digitalization, they have already prepared an e-application. So the person who would want to inquire from the central authority can just file the application online. So they have prepared that application already. And the third one is they also have to prepare the implementing rules. So from the point of view of the central authority, they have not yet prepared the implementing rules for the convention. So what is their guide? Their guide are the provisions in the convention. And if there are gray areas, they look into the rules of what the court has already provided. So hopefully before the end of this year, they would be able to come up with their own rules. So that was for the central authority. Now we go into the courts, okay? The courts, the Supreme Court already promulgated the rules on action for support and petition for recognition and enforcement of foreign decisions or judgments on support. Okay, this is administrative matter number 21-03-02-SC. So part 1, the rules actually, they're comprised 2 parts. So the first part is the action for support. Okay, a child is defined as a person below 18 years of age or 18 years of age and above who, because of a physical or mental disability, is unable to fully support himself or herself. So there is a biological age, there is also a physical and a mental age, provided that there is proof that the child could not fully support himself or herself because of that mental or physical disability. For support, This is a definition taken from our substantive law, which is the Family Code of the Philippines. And it states that support comprises everything indispensable for sustenance, dwelling, clothing, medical attendance, education, and transportation in keeping with the financial capacity of the family. The education of the persons entitled to be supported shall include his or her schooling or training for some profession, trade, or vocation, even beyond the age of 18 years. Transportation shall include expenses in going to and from school or to and from place of work. So in other words, support, even if because our age of minority there is below 18, even if the child reaches 18 and is considered an adult, the child is still entitled to be supported, particularly for the child's education. Okay, so that comprises the definition of support or maintenance in the Philippines. And who are the recipients in the rules on action for support? Who are the recipients? The child is a recipient, and the spouse could also be a recipient. Okay? So this is the procedure, verified complaint and answer, then the pre-trial, then mediation, which is court annexed, and then trial and the judgment, and then the appeal. So approximate period is about 170 calendar days, so that's about 6 months. Okay? Next, this is satisfaction of judgment. Judgment could be paid in cash or certified bank check or any other form of payment allowed under the rules of procedure. If payment cannot be made in cash or certified bank check, the following measures may be availed of. Number 1, garnishment of debts or other credits. B, satisfaction by levy. C, deduction from salary. D, withholding of pension, retirement, and other funds. E, such other measures authorized by law and the rules of procedure. And without resorting to the foregoing measures on joint motion, the parties may avail of court-annexed mediation for purposes of voluntary compliance with the judgment. So this particular provision in the rules on action for support, this was taken from Section 16. This is rather Section 16. And this last paragraph is taken from Article 34 of the 2007 Child Support Convention. This paragraph, actually, this is something new in our jurisdiction. Because why there is already a court judgment, why do you still give them a chance to to engage in mediation? Why? So we discussed this among ourselves, and actually we got it we shared our experiences, and we said, actually, there could be supervening events. From the time the decision was rendered by the court, supervening events could happen. What could be an example? An example would be this particular amount is given, and the obligor has to give this particular amount. However, suddenly, the obligor suffers a physical ailment, a physical illness, and he has to pay for his medical needs. So can that person still continue to give the amount of support stated in the decision? So that could be a supervening event. Another supervening event could be that the amount could be higher because the child is undergoing special treatment. So how is this? How can we comply? Or will that be realistic rather? So when we saw this provision in the Hague Convention, it actually it confirmed our experience because I was a judge in the family court for 12 years before I got to the Court of Appeals. And I really found out that many things could happen in between. If we have to be realistic about it, mediation is a good thing. And another thing about mediation, because not only that it's going to deal with supervening events and realistic things that are happening in our lives, another thing is that it will give the parties voluntary compliance with the agreement, with the decision, because that will be the basis for the decision of the court, or that could be the basis for execution of judgment. So it gives voluntary compliance. Why? What is the difference between voluntary compliance and compulsory compliance? Compulsory compliance is that you have to look for the debtor, you have to look for the obligor. They usually go away. They don't appear. You try to locate them, it's hard to look for where they are. So, and where's the property that we can put some levy? Where is the bank deposit that we can get? Where is the salary? It's hard to locate. So what will the judge do? They will say, oh, order him to come to court. He doesn't come to court. So what's the next thing to do? Cite that person in contempt, right? Cite that person in contempt of court. And one of the penalties there is to put the person in jail. Okay? That's one of the remedial measures. Will that, practically speaking, will that make that person comply with the decision on support? Putting that person in jail? So in other words, that's compulsory. That's compulsory compliance. If there is voluntary compliance, that kind of event will never happen. Because the person who is obliged to give support, the obligor, will do it voluntarily. So it's not going to be hard. And at the same time, if he does it voluntarily, the recipient could see it. And it is going to encourage them. It will stave off, it will fend off enmity between the parties. It's going to encourage them to have a harmonious relationship. Okay, and drive off enmity and have good vibes with each other. So that's why when we saw the convention, this particular provision in the convention, we included, because we had acceded to it, we included it here and in our rules. And at the same time, as Justice Amy Javier of the Supreme Court, she is our chairperson on the Committee on Family Courts and Juvenile Concerns. We are already preparing the rule on family mediation, because we see how important it is in maintaining a civil relationship at the very least between the parties and the children, and in promoting a harmonious relationship between the family members. So, so that's very good point that we got from the convention. And next will be, this is a second part on the rules on action for support. This is for the petition for recognition and enforcement of foreign decisions or judgments on support. Okay, where to file? The court territorial jurisdiction over the place, or where any of the properties of the respondent is located. If the respondent does not reside in the Philippines or whereabouts cannot be located. Procedure, see, it's very short. It's only like 2 months. Petition, and then comment, and a hearing. There is no trial because there's already a foreign judgment. So just a hearing to clarify things, and then the matters, and then decision, and then the appeal. And the judgment is not stayed by an appeal, and there will be execution of judgment. So please note that the physical presence of the child or the applicant is not required at any stage of the proceedings. Okay, so common provisions, confidentiality, we got this from the convention, but actually in our country, in the domestic law, creation of the family courts, in the Republic Act 8369, it expressly provides that all cases in the family courts are confidential. Everything, all proceedings, even the records, all are confidential. So, but we just had to include this in the rules. Okay, also non-disclosure of information in exceptional circumstances. Okay, so we also included that. So now, as to the number of cases filed per year, the rule on action for support, 40, 50. So you can see the increase in number, okay? 146 at the moment. And nature of case, support with applications for support pendente lite, petition for support, violation of Republic Act 9262 is anti-violence against women and children. This is more on domestic violence. Support, but with there's a claim, or rather an allegation of domestic violence. And then support with other remedies, petition for recognition, visitation rights, and even for DNA testing. Okay, so most cases are with support and application for support pendente lite. Pendente lite means while the case is pending. Okay, so recognition enforcement of foreign judgments, look at the increase from 7 to 6 and then 22. So I'm sure by the end of 2023, that's going to be much higher, 24. Okay, considering that we have a lot of Filipinos overseas and Filipinos who may have intermarriages, different countries. So wait, I'm not done yet. Wait, so I just want to mention this, how important, how valuable this convention is to us. Because we have a lot of foreign workers, of course, here in Hong Kong. We see Filipinos here around. And these overseas Filipino workers have intermarriages, or they could have relationships abroad, and then they have children left behind, or they could have children abroad. So this will not deprive them of a chance to be able to get some support for their children. And the institution of the central authority is actually of great help because they can have administrative remedies already without going to court. But the option of going to court is still there. Okay, so, there's also in the convention that the central authority can help them. If they want to file a case in court, the central authority can assist them and provide for legal service for them. So that's a very plus point for us. Okay, and I also would like to mention that because of all these cross-border disputes, we are actually, the Philippine judiciary, the Supreme Court is also very proactive, and we have already, actually for an annulment of marriage, we have already expanded the scope even to those who are working abroad. Overseas Filipino workers can already apply even online for, we don't have divorce, but we have declaration of nullity of marriage. We also have annulment of marriage. We have legal separation. The closest to divorce is declaration of nullity of marriage. They can already apply for that. So it's a recognition of the globalization of everyone in the world and our interconnection with each other. That's why and of children who could be born, who could be from another country and then reside in another country. So that's how reality is already is. So and that's why we thank the convention of the HCCH for suggesting this to us like 4 years ago. And so when we examined it, it truly works for us. Incoming, so just to say this now for my colleagues in the Asian Pacific region, it will not only handle incoming cases, the cases that go to your country, it will also handle cases of our own citizens who may be residing abroad, outgoing cases. So it's not only for those coming in, but even also for our own citizens who may be coming in or going out of the country. Okay? So, thank you very much po. Thank you very much po.
Thank you. Thank you very much,
But
Ms.
it's not
Pimplesail. We
working.
enjoyed your presentation very much.
It's not working. I wanted to show our for my last one, it doesn't show anymore. Just the last 2 pages. There. Mabuhay.
Mabuhay. Thank
Salamat
you.
po.
Thank you very much. Well, continue sharing the regional perspective. Lastly, let's welcome Mr. Chow to the podium.
Good afternoon, ladies and gentlemen. I'm aware of time, so I will keep my speech as short as possible. Now, the long and short of it is that Hong Kong has not acceded to any of these 2 conventions. All right, so I can conclude it. No. I would like to take this chance to share some differences in the legal concepts in the 2 conventions and those legal concepts with the Hong Kong legislation and the local law, all right? Now, first of all, although Hong Kong is not a contracting party to these 2 conventions, Hong Kong is a party to the United Nations Convention on the Rights of Persons with Disability, the UNCRPD. And amongst other things, Article 12 of UNCRPD seeks to promote supported or assisted decision-making by persons with disabilities. That is the basic concept under the UN CRPD. Well, if we just move on, we will see the differences of the concept between UN CRPD and those in Hong Kong legislation. Now, the existing comprehensive legislation relating to mental health and mental capacity in Hong Kong is the Mental Health Ordinance. We usually call it the MHO. Now, from a civil perspective, in relation to the protection of mentally incapacitated person, or we just call it MIPs, there are mainly two parts. A two-tier system from civil perspective to protect adults who are mentally incapacitated. Part 2 of the MHO relating to the administration and management of the property and financial affairs of MIP. And the powers are exercised by the High Court, which is the court of first instance. And the second part of it is Part 4B, relating to the personal and medical cares of MIP. But the power are exercised by the Guardianship Board, which is a statutory body, not necessarily part of the judiciary in Hong Kong. Therefore, in Hong Kong, we don't have a unified adult guardianship system here. So we have to go to two bodies in Hong Kong in relation to the protection of incapacitated persons, adults. Now, and the jurisdictional applications are under the MHO. It is quite clear under the MHO because, well, if you look at the convention, the 2000 convention itself, we usually refer to the concept of habitual residence of an adult. However, Part 2 of the MHO only said that an application can be made if the MIP concerned is subject to the jurisdiction of the court of first instance. But there is no further explanation as to who qualifies. And equally, under Part 4B, is even silent on whether MIP concerned should be domiciled or habitually resident in Hong Kong before the Guardianship Board may exercise the power. All right? Also, MHO is of a relatively confined application. The concept of mental incapacity and mentally incapacitated person are those used under the MHO. On the other hand, the 2000 convention seems to have purposefully avoid using the term incapacity. Instead, it refers to impairment or insufficiency or of their personal faculties. So I suppose that it will have a wider application than the MHO to include adults of other kinds of physical disabilities or impairments. But it comes to the question of how to reconcile the differences between the two systems. Despite that, like many other common law jurisdictions, the concept of vulnerable adult who is not necessarily mentally incapacitated is now developing in Hong Kong under the High Court's inherent jurisdiction. But well, we are still at a very primitive stage in the development of this concept. So in future, if we are going to accede to this convention, then there may be some problem about the concepts. And how to reconcile it may be one of the questions we have to deal with. Right? And the protection of MIP, or the incapacitated adults, under Part 2 and Part 4, sorry. Yes. B, essentially is a substituted decision-making model, which means that a person appointed will replace the MIP concerned to make decisions concerning the MIP himself or herself. And the MIP basically will have no say if he's found to be incapable, all right? And it means that he will be totally deprived of the decision-making power. On the other hand, if we just look at the convention itself, the 2000 convention, Article 3B implies that an adult concerned may still retain a certain degree of autonomy, but under the protection of a judicial or administrative authority. Article 3B further suggests that the person appointed for the adult may play the role of assisting the adult concerned in making the decision. And it is more consistent with the concept under Article 12 of the CRPD. Right? Now, in relation to the 2007 Child Support Convention, Maintenance Orders Reciprocal Enforcement Ordinance, Chapter 188, is the main legislation in Hong Kong relating to the reciprocal enforcement of maintenance order. However, Cap 188 only has limited application between Hong Kong and some other country, usually the former or current Commonwealth countries. All right? And also, its limitation is also concerned with the nature of the maintenance order. We only apply to periodical payments order, but not any other form of child support or maintenance for the family. And there is another piece of legislation which is specifically applicable between the mainland of PRC and Hong Kong, which is the mainland judgments in matrimonial and family cases, reciprocal recognition and enforcement ordinance, Cap 639 of the legislation in Hong Kong. And this is an ordinance to provide for the recognition and enforcement of in Hong Kong of judgments in matrimonial family cases, including those maintenance obligations given in the mainland for facilitating the recognition and enforcement in the mainland of such judgments given in Hong Kong. Therefore, for this ordinance, it doesn't only apply to maintenance obligation, but it also applies to orders made in the mainland China relating to other aspects of family disputes, including custody orders. Okay? And there are some other features which I wish to highlight in relation to the differences between the convention and the local law in Hong Kong. First of all, the 2007 convention requires the designation of a central authority. Central authority under the convention shall provide assistance in relation to applications under Chapter 3. In particular, they shall, first of all, transmit or receive such applications and initiate to facilitate the institution of proceedings in respect of such application. Now, in Hong Kong, there is not yet any centralized or official child or spousal maintenance recovery agents. And payees of maintenance, local or abroad, need to make their own application to the Hong Kong SAR court for the enforcement of maintenance in arrears themselves. If they do not have the financial means to do so, they can apply for legal aid in Hong Kong. But there is no centralized organization to enforce this kind of maintenance obligations for those payees of maintenance obligation. In contrary, or to compare, under the Child Abduction and Custody Ordinance, which is the legislation to enact the 1980 Convention, the functions and the duties of the central authorities under this convention are discharged by the Secretary for Justice in Hong Kong. And moreover, there is another feature which may make a difference between the local law and the convention. The 2007 convention covers maintenance obligations arising from a parent-child relationship towards a person under the age of 21 years old. On the other hand, in Hong Kong SAR, maintenance obligation towards a child of the family may be extended to the time before that child has completed full-time tertiary education, which means that it can be beyond 21 of age. Okay. Further, the convention prescribes that contracting parties shall make available in internal law effective measures to enforce decisions under the convention. However, if we look at Article 34, Paragraph 2 of the 2007 Convention, we'll find there are a number of measures recommended by the convention. However, some of them are not currently available under the local law in Hong Kong. For example, credit bureau reporting and denial of license. So it comes to the end of my speech, and I wish to, take this opportunity again, welcome to Hong Kong for those who come from other countries and other member states of the Hague Conventions. And I hope that I will see you again very soon. Thank you very much.
Thank you, Mr. Chow. Thank you for a great speech. And let's give it once again to all the panelists. Thank you for your invaluable sharing. Thank you so much. Well, ladies and gentlemen, with such wonderful sharing, our 4-day conference is coming to an end. As we come to the end of this remarkable conference, we're very honored to invite Mr. Horace Zhang Guoquan, Deputy Secretary for Justice of the Hong Kong SAR of the People's Republic of China, to deliver the closing remarks. Welcome to the stage.
Dr. Scholar, distinguished guests, ladies and gentlemen. I'm very glad to have you with us and that the Asia Pacific Week 2023 ends on a high note today. I would like to express my appreciation to the Permanent Bureau of the HCCH for hosting this meaningful and impactful event in Hong Kong. I wish also to thank the HCCH Regional Office for Asia and the Pacific, as well as the Faculty of Law of the University of Hong Kong for their contribution and support. My gratitude goes to all the speakers for their insightful presentation and comments, and to all our audience for your active participation. I recall the reception hosted by China in March this year for the distinguished delegates who attended the HCCH Council on General Affairs and Policy meeting in The Hague. On that occasion, I extend our warm invitation to all the prominent guests to come to Hong Kong in person for the 6th HCCH Asia Pacific Week in celebration of the 130th anniversary of the HCCH, as supported by the Department of Justice of the Hong Kong Special Administrative Region. I'm glad to see some familiar faces and know that you have accepted the invitation to come to Hong Kong. At the reception in March, I also briefly introduced to you about Hong Kong as an international legal and dispute resolution service center in the Asia-Pacific region. And now you have come to witness the unique strength of Hong Kong by yourselves. Under the principle of one country, two systems, Hong Kong is the only common law jurisdiction in China, and our bilingual common law system has a strong heritage and is reputable in the global community. It's in touch with the developments and changing needs of the contemporary world. Our courts exercise judicial power independently, free from interference, and the rule of law tradition is also firmly enshrined under the Basic Law. The focus of this year's Asia-Pacific Week is on three core values in our modern-day legal landscapes: access to justice, sustainable development, and interconnectedness. This is perfectly in line with the Belt and Road Initiative launched 10 years ago. As a significant development strategy, the Belt and Road Initiative aims at promoting cooperation and enhancing interconnectedness among countries and regions along the Belt and Road routes, which at the same time facilitates access to justice and sustainable developments. To celebrate this 10th year milestone, the Hong Kong government is in tandem organizing a two-day Belt and Road Summit officially launched yesterday, and we are honored to have Dr. Bernasconi, Secretary General of the HCCH, sharing his invaluable insights on how the Hague instruments could promote trade and investments in the Belt and Road region through the progressive unification of private international law rules. We are grateful for the Secretary General's support and participation in person in all these events in Hong Kong, including, of course, this Asia Pacific Week. It testifies the long-standing partnership between Hong Kong and the HCCH, made possible by the support of our central government in various global and regional legal initiatives, and shows the many possibilities of cooperation in alignment with Belt and Road Initiative. In the context of the diverse legal systems of the Belt and Road countries, we stand ready to make contributions to the harmonization of private international law rules for better coordination of private relationship in international situation. Hong Kong has abundant experience in bridging the common law and civil law divide. Our basic law makes it possible for Hong Kong to establish a comprehensive mutual legal assistance (MLA) framework between the mainland and Hong Kong. The Guangdong Hong Kong Macau Greater Bay Area (GBA) development plan also provides a fertile ground for the convergence of legal practices and the advancement of MLA among the three distinct jurisdictions within one country. Indeed, the GBA task force, which I'm now chairing, is working towards the enhancement of our cooperation in a wide range of civil and commercial matters, so as to provide further convenience and benefits to individuals and businesses living and working in the GBA. The Hong Kong Mainland MLA framework is currently consists of 9 arrangements covering a wide range of civil and commercial matters, including service of documents, taking of evidence, and recognition and enforcement of judgments. Many of these arrangements are modeled on the relevant Hague Conventions, such as the Hague Service Convention, Evidence Convention, and the Judgments Convention, which serve to bridge the gaps between the civil law and the common legal system, and our arrangements with mainland provide an excellent illustration on the importance and value of the Hague Conventions in bridging such gaps. Hong Kong has indeed privileged to participate in the work of HCCH for more than 2 decades. Since 1998, representatives of the Hong Kong Special Administrative Region, as members of the Chinese delegation, have taken part in the meetings and other works of the HCCH. Working closely with our counterparts in the central government and the Macau Special Administrative Region, we participated in the special commission meetings and the diplomatic sessions. We are also honored to contribute to the work of HCCH through various means. For instance, 2 informal working groups under the Judgment Project. Together with the Global Conference promoting the convention shortly after its adoption, were successfully held in Hong Kong in 2019. In addition, we concluded a memorandum of understanding for the technical arrangements relating to the secondment of the legal professionals between HCCH and Hong Kong Special Administrative in 2020, and the Council from my department is also on secondment to the Permanent Bureau in The Hague at the moment. Ladies and gentlemen, by hosting this Asia Pacific Week in Hong Kong in celebration of the 130th anniversary for HCCH in the Asia Pacific region and the world, it sends a clear message that Hong Kong is now back on the world stage. We cherish the reunion with our old friends and the bonding forged with our new guests. We hope you all have an enjoyable stay here, experience firsthand the attractive, vibrant, and dynamic life of Hong Kong, our beloved city. We look forward to welcoming you all again in Hong Kong for other meetings, business, or just vacation in the near future. Thank you.
Thank you. Thank you very much, Mr. Chung, for your wonderful remarks. Thank you. Well, ladies and gentlemen, lastly, please welcome Professor Geraldine Goh Escola, Deputy Secretary General of the HCCH, to deliver the closing remarks. Welcome to the stage.
Honorable Deputy Secretary Horace Chung, Deputy Secretary for Justice, the Hong Kong Special Administrative Region of the People's Republic of China, Excellencies, Honorable Justices, distinguished guests, and dear friends. On behalf also of my Secretary General, who regrettably cannot be here with us in person today, but has been here all week. I think he's somewhere flying above mainland China at the moment. I am delighted to thank you all and to congratulate you on another successful HCCH Asia Pacific Week. Once more, this week has proven to be a cornerstone gathering of the HCCH and a crucial way to engage with its networks in the Asia-Pacific region. Now, this week has been momentous and historic. We celebrated not only the 130th anniversary of the HCCH, a venerable anniversary by any measure, but also marked the entry into force in a little over 4 years of the 2019 HCCH Judgments Convention. In a world today facing increasing uncertainties and challenges, the fact that the Judgments Convention, a framework for international trust and legal cooperation, enters into force under the average time usually taken is, I believe, reason for optimism for the unifying force of private international law and the work of the HCCH. Now, beyond the celebration of important milestones and anniversaries, you, our strongest supporters and allies and the best advocates of the HCCH, have come together to show the strength and the further potential of the HCCH conventions, instruments, and projects. This week, we have in our discussions contemplated the theme, which the Deputy Secretary has already spoken to you about, of access to justice and sustainable development, the impact of the HCCH in an interconnected world. These discussions have reinforced how sustainable development requires engagement across all dimensions and across the globe, requiring the collective and coordinated efforts of individuals, businesses, governments, and civil society. Now, for this reason, it is not surprising to see how the HCCH conventions and instruments, which are fundamentally tools for enhancing cross-border interconnectedness and dialogue, are integral to the advancement of the Sustainable Development Goals, especially in a heterogeneous region such as Asia and the Pacific. Our tasks, as eloquently set out in this week's presentations, are to ensure that the HCCH continues to be a fount for pragmatic solutions in the transnational and cross-border challenges that arise. As we heard earlier today, our suite of HCCH conventions and instruments in international family and child protection law allows us to continue supporting individuals and the family as a basic unit of our communities and to protect our most vulnerable. Yesterday, we explored the regional and global benefits and opportunities that the HCCH portfolio of international commercial, digital, and financial law instruments and projects bring to sustaining and achieving, sustainable development, financial inclusion, and the participation of individuals and businesses in the global economy. This week, we witnessed as well how international legal cooperation and frameworks for transnational litigation ensures access to justice, which is a fundamental piece of the puzzle of global trade and commerce and the protection of human dignity and human rights. The HCCH conventions, when properly implemented and operated, are a powerful toolkit to assist governments in achieving the Agenda 2030. The work program of the HCCH, including the working groups on jurisdiction and parentage and international surrogacy, as well as the work addressing global digital transformation and financial inclusion, comprise the HCCH efforts to ensure relevant, timely, and feasible steps are taken to provide a robust international legal framework in rapidly evolving times. The HCCH and its technical secretariat, the Permanent Bureau, continue to work towards strengthening the proper operation of our instruments and conventions to assist members with particular challenges and increase awareness of the benefits of engagement through membership and accession to HCCH instruments and to track developments in order to anticipate and meet the new needs of our members and of the world that can be addressed with potential future work. Now, as we close another successful HCCH Asia Pacific Week, this time from heartbreakingly beautiful Hong Kong, we look to our next activities and engagement with the region. Now, as we say, the end of one Asia-Pacific week successfully done is the start of work for the next one. And so the race to be the host for the next Asia-Pacific week has already begun, and we look forward to further expressions of interest from members in the region and to being back in the Asian Pacific very soon, following on a very successful week this week in Hong Kong SAR, last year in Manila in the Philippines. 那在我结束发言之前，请允许我代表海牙国立司法会议，感谢中华人民共和国，特别是香港特别行政区政府和香港大学，感谢他们为主办海牙国立司法会议 HCCH 亚太州香港2023所提供的慷慨支持。我们很高兴海牙国立司法会议亚太州今年可以重返香港，并期待与中国和香港继续密切合作。感谢所有亲临美丽的香港，以及从世界各地连线参与我们的活动的同事和朋友们。And so in English, before I end, and before I massacre this beautiful language any further, allow me to thank the beautiful People's Republic of China, a member of the HCCH, and especially the government of Hong Kong's Special Administrative Region and the University of Hong Kong for their generous support in hosting HCCH Asia Pacific Week Hong Kong 2023. We are delighted that the HCCH Asia Pacific Week returned to Hong Kong this year and look forward to continued close cooperation with China and with Hong Kong SAR. Thank you to all colleagues and friends who joined us in person here in beautiful Hong Kong and online from around the world. And as always, allow me then to abuse the privilege of standing here and thank and give our special appreciation to the Regional Office for Asia and the Pacific of the HCCH seated here in Hong Kong. Our representative, Professor Yun Zhao, who's also now with our Secretary General on his way to Wuhan. Our office manager, Alex Ng, who made everything go, and I don't see Alex, but she's somewhere around. She's making things run. Levi Gao, who was fantastic and was around not just this week, but throughout the entire year. Our secondee, Diana Wan. And we have Benjamin Go as well, somewhere in the room, who's an intern from the regional office. And let me thank as well the extraordinary effort that they've gone to organize and coordinate this year's Asia Pacific Week. They continue to do amazing work day in and day out in this region from the seat in Hong Kong. Allow me to thank also all the organizers, speakers, and panelists who joined us this week. And once again, I congratulate all the participants for this very successful Asia Pacific Week 2023. And I thank you for being with us to celebrate anniversaries, milestones, birthdays, the entry into for us of a very new instrument. And I look forward to our next gathering. 我们下次活动再见，谢谢. Thank you very much.
Thank you. Bravo. Bravo to HCCH. Bravo to Escola. Thank you so much for putting a very perfect ending to our conference. Well, there's nothing more I could add. Ladies and gentlemen, that's all for HCCH Asia Pacific Week 2023. Thank you for being a part of this wonderful event in Hong Kong. I wish everybody all success in all your endeavors. Thank you so much. Enjoy your time in Hong Kong. I wish you to see you again in Hong Kong. Thank you. Well, ladies and gentlemen, there's